Good afternoon. Hi, Madam Court Reporter. Are you here to take down this proceeding?
Yes, I am.
Hey, have you got the information that you need from the lawyers, and are we agreeing to take down for the benefit of the court reporter?
We agree.
Okay. Are y'all, who are the, I guess, two main attorneys on this? And are y'all splitting the fees?
We haven't talked about it, but that's fine with me. Derek, is that okay with you?
Yeah, absolutely.
Okay.
And we can split it three ways. Matt
that's right.
Lazarus here as well.
Okay.
Ms. Watson, do you need anything else from them?
That is it.
Okay, we're going to go ahead and go on the record then, Madam Court Reporter. This is going to be a hearing in the matter of Paula Harmon and Pediatric Ear, Nose, and Throat of Atlanta versus Michael Weinstein. I hope I'm pronouncing that correctly. And Northside Hospital. Case number is 26 CV 000468. Let me start by getting announcements from everybody, starting with counsel for Dr. Harmon and Penta.
Yes, Your Honor. Matt Boyd for the plaintiffs with Tucker Ellis here in Atlanta.
And who do I have here on behalf of Dr. Weinstein? And is it Dr. Weinstein?
It is Matt Lazarus, Your Honor.
And Mr. Bauer, you are here on behalf of Northside Hospital, correct?
Yes, Your Honor, with a large cast as well. Also with me are my colleagues Katie Lucas and Marcella Flowers on camera, because they will also, with the court's permission, be handling some of the issues depending on how the court wants to proceed. And I've got with me in my office two of my colleagues, Ashley Guffey and Hillary Friesmeyer.
Okay. Okay.
Your Honor, I've got Dr. Harmon here with me as well, just observing as a party.
I saw Dr. Harmon on the screen and assumed that she was here as a party. Thank you for pointing her out, Mr. Boyd.
And Judge Krause, I should also introduce Northside Hospital's Vice President of Legal Services, Ashley Alfonso, who's also present.
Hello, Ms. Alfonso. How are you?
I'm good. How are you, Judge?
I'm doing well. That was meant more rhetorically. Sorry to put you on the spot to make you unmute. Okay, so what I like to start with doing is to sort of let you know where I think this case is postured procedurally, so that maybe we can dispense with some issues, and then y'all have a clear idea of what you need to correct me on if I've maybe misapprehended it from your perspective, or what you need to educate me about if it's something that you think is important that I've not mentioned. So there are a whole ton of motions, right? But here's what I understand. Dr. Harmon and her medical practice routinely used the facilities, certain facilities that belong to Northside Hospital, to perform surgical and medical procedures on her patients. And there is a doctor at that facility or in some way associated with Northside Hospital. And I say that as broadly and vaguely as possible, because I know that's one of the issues in the case. Who I believe is an anesthesiologist, but I could be mistaken on that one. But in any event, I think it's safe to say Dr. Harmon and Dr. Weinstein not fans of each other, and that there came to be a particular circumstance between Dr. Harmon and Dr. Weinstein. And Dr. Harmon alleges in this complaint that Dr. Weinstein is a problematic actor who has taken actions on his own that constitute torts, and or on behalf or as an agent of Northside Hospital against her. And what that resulted in is a couple of things, and that's where we get into this sort of laundry list of motions that we currently have pending. So first, I have a good old-fashioned 12B6 motion to dismiss, right? And that is, I believe, filed on behalf of Northside Hospital. I do also have one from Dr. Weinstein as well. And then I have a motion to strike certain scandalous material under 911. Is it 12F? Those are not ones that come up very often, but I certainly understand why it was asserted in this instance. And then I have what I think actually got you all a hearing today in front of the court is a 911 11.1 motion to strike, asserting that this is a SLAPP suit against either or both Dr. Weinstein and Northside Hospital. So Also, I will note that part of the relief sought by Northside was to do some limited discovery as to a claim that Dr. Harmon has asserted in her complaint about intentional infliction of emotional distress. The court granted that motion originally, and I am aware that Dr. Harmon's counsel filed an emergency motion to seal, filed an emergency motion for the court to reconsider that. And then now we also have this added layer of a request to subpoena Dr. Harmon to compel her testimony today. And so let me start by saying this. I was just handling a 9/11/11.1 hearing 2 days ago. They seem to come in batches, and I have about 4 of them right now. So I have had cause to very recently review the law and the structure and the procedural process that we are supposed to engage in for a 9/11/11.1 motion to strike. While I don't believe I agree entirely with the plaintiff that no discovery is implicated or allowed, I don't necessarily think it is not my preference for us to get down into the trenches of examining witnesses and active discovery if we can avoid it. Now, that doesn't mean that I don't think it's authorized or allowable, but I don't think I want to avoid it if we can, unless it is really inexcusably necessary. And that's just my perspective on that matter. My feeling is that the motion to dismiss, the good old fashioned 12B6 motion, it really ends up when when it coincides with the 9/11/11.1 motion, it ends up getting subsumed by it, primarily because if you don't succeed on the 9/11/11.1 step 1, then you don't have to get to 9/11 or to the second step, which is can you survive a motion to dismiss, essentially, a good old-fashioned 12B6? Is there a likelihood of prevailing on the merits, which I believe the case law, again, y'all can disabuse me if you think I'm wrong about it, but I believe the case law says that it says reasonable likelihood of prevailing on the merits, but the way the courts have interpreted that is let's apply that sort of dismissal standard. Have they stated a cause of action that might survive? And then we have this separate issue about the allegedly scandalous allegations as to Dr. Weinstein. So that's the procedural background that we're in. My inclination for saying all that is I would be inclined to start with the 9/11/11.1 motion. And then the only real question is, do we want to, who's going to go first, Northside or Dr. Weinstein?
We would
So-
just put north side.
Yeah, if I may, Judge,
Yes,
I
sir.
discussed this with Mr. Lazarus yesterday, and he was fine with Northside proceeding on that motion since it's Northside's motion and not Dr. Weinstein's.
Okay. And then what my typical practice is, and like I said, this is going to get a little messy because, right, we've got a lot of motions back and forth. But right now, what I would like to do is focus on the legal arguments that have been asserted by Northside pursuant to 9/11/11.1. And then I would hear from Mr. Boyd in response on behalf of the plaintiff. And then what I would do, as is my practice, is if it's your motion, you get the last word, right? So I'm going to let you have some sort of rebuttal. And that's the path we're going to go down. I would ask, I promise I have read your briefing and I am familiar with the facts as they are pled anyway. And so part of the reason I just engaged in all of that is so you don't have to actually go backwards and say, oh, she practices at the surgery center and she's this. And let's try and dispense with that unless it's a critical fact that you really need to bring into specific relief for me so that y'all can be more efficient with your presentation and we don't have to sit here for 4 hours. So with that, Mr. Bauer, please go ahead.
Thank you, Your Honor. And it is nice to see you from the bench rather than your car, which is where I think the last time we had the pleasure of being together.
That is true. I did handle an emergency motion from my car one time.
It was not my emergency motion, though. I want to make sure the record's clear on that. But we appreciated your willingness to do that. And it's a privilege to be back in front of you under more regularly scheduled circumstances. I will, before I sort of launch into my spiel, I think I agree with you on your assessment of the anti-SLAPP standard with one exception, even though the courts of appeal have directed us to analyze the plaintiff's burden on those motions by crediting the evidence that the plaintiff brings forward or has pleaded by affidavit in support of their claim, they still have an evidentiary burden and it's still an evidentiary standard. And so I do want to put a little bit of evidence in the record. I mean, we've submitted it all by affidavit, but I want to direct you to some of it on the record so that you know, why we think those facts are important to your evaluation of the anti-SLAPP standard. I promise I'm not going to try to rehash any of the facts, and I will stay focused on really just what I think are the key points we want to make here. As you've likely noticed, Northside has a very big team defending this matter. I'm going to introduce them to you, or I kind of already have, but I want to make sure you understand why that is. We do have these significant dispositive motions that we've overloaded the court with right out of the gate, but I think the court needs to understand why this is just a very important case to Northside Hospital. To give you some context, Northside has more than 4,000 credentialed physicians on its medical staff, most of whom operate in a high intensity, high stress, life or death environment every single day. And so this case comes to you in a context in which every physician, every staff member at Northside encounters conflicts almost every single day. Conflicts between physicians and staff. Those are an everyday, many times a day occurrence in a hospital environment. And for that reason, Northside Hospital, just like every other hospital, has robust policies and procedures for conflict management and a robust peer review process through which the medical staff members police themselves. And that is a process required by Georgia law, because it is the policy of this state, and frankly, every other state, that we want doctors reviewing the care and behavior of doctors, not lawyers and hospital administrators. That's how our ground level healthcare system is set up as a matter of public policy. And that's why we have laws mandating that hospitals have a peer review process for those functions. And in almost 26 years that I've had the privilege of representing Northside Hospital in medical staff matters, I've seen many, many altercations, OR altercations, breakdowns, screaming matches, disruptive physicians, disruptive staff, psychotic patients, you name it. We've seen it, we've encountered it. But in 26 years of doing this work, Judge, no physician on our medical staff has ever completely disregarded the hospital's policies and protocols and escalated a personality dispute with another provider into what has become a massive operational disruption to a surgery center's operations. And frankly, what this hospital perceives as a shakedown campaign based on a threat of negative publicity and a promise of continuing disruption if it doesn't capitulate to unreasonable demands. So the court needs to understand Northside's response to these tactics is being watched by 3,900 other credentialed medical staff members. Our preference has always been to have our grievances among our medical staff addressed through proper channels. That's peer review, which is a process available to every practitioner who believes another physician is behaving inappropriately. But here we are. And not only did Dr. Harmon choose to bring her grievance here and disregard those policies and procedures that are mandatory for her eligibility to maintain privileges at our facilities, but she did it in the most aggressive and damaging way possible in order to put tremendous pressure, or what she perceived to be tremendous pressure, on the hospital to resolve this rather than defend itself in a public proceeding. But Northside does not have that luxury, Your Honor. It is a nonprofit organization. It is subject to federal and state not even tax exempt laws, regulatory laws that prohibit it from, as an organization, just writing a check to a doctor that has no meritorious legal claims, even if it wanted to do so.
Mr. Bauer, before
Yeah.
you fully move on to a different topic, on the point of publicity and those other issues, probably should point out that in order to satisfy my obligation to have an open courtroom, this matter is being live streamed to YouTube. So two things that are important about that. One is you might want to conduct yourselves accordingly, because you never know who's watching, although probably it's nobody or like two people. But second thing important about that, you do have a court reporter here, but I do find that I have to point out to people that the video is an artifact of how Google records things on YouTube. And so it is not an official court record, and it is not something from which anyone can create an official court record. The official court record is the transcript that is being built for you right now by the court reporter. So those are my 2 points on that issue. And your reference reminded me that I had forgotten to say it at the beginning. Sorry for the interruption, Mr. Bauer.
No, I appreciate the reminder, Your Honor. And, we are aware that there are sensitive, and as you know from our 12F motion and the anti-SLAPP response, there are matters we think that have been tendered into this case already that are impermissible in the sense that, peer review is a thing that we all know exists, but it's not supposed to show up in our civil litigation unless it's on the other side of a peer review action. But we also know that, because you did not deny, or since you granted the request for discovery and Dr. Harmon did provide some sensitive information as part of her response to that order, we've tailored our presentation knowing this is a public proceeding. We're not going to talk about confidential peer review information. We're not going to talk about medical information, at least not on the record. But we may direct you to some of the filings as needed. And we tried to actually tailor our public filings accordingly. I don't think we need to actually put that stuff on the record in order to make the points we need to make. But suffice it to say, Your Honor, this is a very important case to Northside. It is obviously prepared to defend itself aggressively, as we think the complaint requires us to, and hence the large team and the important preliminary motions practice. So I will start on the anti-SLAPP motion in a second. I just want to let you know who's going to do what.
Okay.
If we get to it, my colleague Marcella Flowers, who is in the bottom right, Hollywood Squares corner on my computer screen, is going to argue that Rule 12F motion if the court is willing to hear it. And we're proud to tell you that Marcella joined our team out of Georgia State Law School just last September, and is a stellar member of our team. And then my colleague Katie Lucas, who's in the upper right corner of my Hollywood Squares, is going to argue the 12B6 motion if you need it.
Okay.
And then, of course, I introduced Miss Alfonso, who is not just, by the way, the Vice President of Legal Services. She's also Vice President of Risk Management. I need to make sure that's clear on the record. So the anti-SLAPP motion to strike, Your Honor. As you know, this motion is based on plaintiff's contention that they can sue Northside Hospital for intentional infliction of emotional distress based on its referral, in part, based on its referral of Dr. Harmon's professional conduct for review by the medical staff pursuant to Northside's medical staff bylaws and policies. So I know you've got a pretty good handle on the facts, but I want to make sure there's some level setting here that's going to be helpful context for all of that if I can. Dr. Harmon is not employed by Northside Hospital. She has privileges to admit patients to Northside facilities subject to Northside's policies and procedures. The rights and obligations that attend to those privileges are set out in Northside's medical staff bylaws and policies. And importantly, Your Honor, they do not include the right to admit as many patients as a physician wants whenever they want. Northside retains full discretion in how to manage its operations, who gets to use what operating rooms and when, in what facilities and when. In other words, just because you have medical staff privileges at a hospital does not mean you get to dictate hospital operations, including staffing, scheduling, etc.
How much of that, though, is governed by corporate policies and procedures adopted by Northside Hospital as opposed to peer review structures that are maybe an order of magnitude different?
So actually, it's all medical staff. And so you've got those policies, and I'm not going to walk you through all of the structure of them, but I will show you the relevant provisions. But the medical staff, which is, it's called the organized medical staff. So those 4,000 members of the staff that have privileges have voting rights. And while obviously hospital administration provides assistance to the organized medical staff, these are their bylaws, their policies and procedures. They have to pass them, they have to vote on them. And that is all done through what's called the Medical Executive Committee, which are elected leaders of the medical staff. And then ultimately, whatever they do does get sent to the Northside Hospital Board of Directors for ratification so that it becomes an official bylaw and policy of the organization. But it is the medical staff that adopts these bylaws, changes them, edits them, and has to approve any changes to the bylaws and policies and sets them. So these are the rules that govern medical staff behavior at our hospital. And like I said, including peer review, we want doctors doing all of that. We don't want non-doctors telling doctors, this is how you have to do your practice. This is what's going to make you qualified. These are the expectations we have for your education, your training, your experience, and important to this case, your professional conduct. So this is another important piece of this. Having medical staff privileges at a facility does not require a physician to bring patients to the hospital. That is entirely up to the physicians where they choose to practice. So for purposes of the court evaluating the legal duties owed by Northside and its medical staff members and to its medical staff members, those are clearly and expressly delineated in the medical staff bylaws, which privileged physicians must agree to comply with in order to use Northside's facilities. And to be clear, Northside has no privity whatsoever with Dr. Harmon's practice entity, PENTA, Pediatric ENT. I'm not sure what the acronym is, but we have no relationship to Penta, which is a plaintiff in this case and suing Northside. Penta does not have privileges. It doesn't have a contract. It has no relationship with Northside Hospital at all. And that context is important because much of what plaintiff's complaint is claiming is that they purportedly have lost millions of dollars because Dr. Harmon alleges she could have done more procedures at Northside than she actually did because of Northside's and Dr. Weinstein's purported interference with her medical practice. But it is a fundamental truth as a matter of law that Dr. Harmon has never had the right to do any more cases at Northside than it allowed her to do in its sole discretion. And I'll show you the bylaws and policies that make that clear. So with that context.
Before you get there, it would be helpful to me. So I'm looking at an 8-count complaint where there's a mix of causes of action that have been asserted against both Northside Hospital and Dr. Weinstein, just Dr. Weinstein, just Northside Hospital. Although the vicarious liability, it seems like it's maybe an effort to sort of shoehorn all of the other claims into like everything Weinstein did wrong, Northside Hospital is responsible for it. And I understand be straying into the 12B6 motion. That's not my intent. The reason I'm asking the question about what causes of action are you specifically attacking in the 911 11.1 motion? And the reason I'm asking that is on behalf of Northside Hospital, it seems like in order to fit yourself into the 911 11.1 structure, right, which is those 4 ways that you could be engaging in protected activity, speech, or conduct that's protected by it, you have to demonstrate that there is some effort to engage in protected activity. And certainly there's an argument to be made. The peer review process is a protected activity, but the rest of it, I'm not quite sure I guess I need you to help me understand if at the end of this process, if you persuaded me, are you really asking me to dismiss under 911 11.1 or strike, I should say, every single cause of action asserted against Northside Hospital? Or is it just those causes of action that are premised on Northside Hospital's employment of the peer review or medical staff review policies?
It is just the latter.
Okay. And which
That
ones
is
are those from your estimation?
It is. And I think it's only the intentional infliction of emotional distress claim,
Okay.
the way it's been pleaded.
Okay.
But this is such an important issue for Northside, right? Setting aside the 12B6 motion, which is obviously equally important, just the idea that Northside is being sued in a superior court for just making a peer review referral is such a serious implication for the operation of its medical staff that using the anti-SLAPP statute to get an early resolution of that claim in that particular issue and taking peer review, which, as you know, is absolutely privileged. It is verboten. It cannot be used in this kind of civil tort litigation. Getting that out of this case at the outset is vitally important. We cannot be arguing about peer review proceedings in this kind of tort case with a doctor. So that's what the anti-SLAPP statute is focused on. Although I do think because of the burden that the plaintiff has to show she can succeed on that IIED claim, even insofar as it's based on just the peer review referral, I think the evidence that shows she can't succeed on that also carries over to the IIED claim based on all the other conduct that she's alleged, both against us and Dr. Weinstein. To be clear, I think it means all of that has to be stricken, because you're going to have to find, we will be asking you to find that she can't carry her burden, evidentiary burden, on either of the two parts of that claim, which I'll walk you through in a minute, that she needs to. But you are correct. We are focused entirely on the use of petitioning activity, peer review petitioning activity, as the basis of a tort claim for this motion to strike.
Okay.
Okay. So I know you're very familiar with the anti-SLAPP statute. It's been briefed by both sides, so we don't need to walk through that. And as you pointed out, and we agree, I think it's established in settled law that the use of a peer review process by a hospital is an official proceeding for purposes of application of the anti-SLAPP statute, and it's properly invoked here with respect to a plaintiff's attempt to assert a claim that's based on Northside petitioning its medical staff for relief. And specifically, the petitioning is a request that the medical staff formally review Dr. Harmon's professional conduct as a member of its medical staff. And that's all we're talking about too. That's all that's happened, is a request has been made. And now it's up to the medical staff to do whatever they're going to do. So I would like to focus on the second part of the statute. That's once it's determined that the conduct at issue is protected conduct, as we think the case is here, the burden shifts to the plaintiffs to make a prima facie evidentiary showing that their claim is based on conduct, that it's a valid claim and it's likely to succeed. And Your Honor, we submit they can't do that here for two reasons. First, I think just at a zero-sum black and white level, it cannot be that a hospital's election to ask its medical staff merely to review a member of its medical staff's professional conduct and nothing more can be deemed in any circumstances to be so extreme and outrageous as to support a claim for emotional distress. I think they think that has to be a bright line rule as a matter of law, because law requires the hospitals to use this process. And as you'll see, it's the only process the hospital has to address the conduct of an unemployed member of its medical staff, which is the vast majority of our medical staff. We don't have employment contracts.
Right, but just to play devil's advocate for a moment, isn't the statute that you guys are relying on for the generally well-accepted proposition that peer review activities are immune, right? Doesn't it say except malice? And if it says except malice, then isn't that a factual issue subject to evidentiary burden, not a motion to dismiss?
So yes, but that's an entirely different procedural construct, right?
Mm-hmm.
Those immunities apply to actual peer review activity, right? Like all that's happened here is the referral.
Mm-hmm.
Medical staff, look at it, do whatever you want. And as you'll see, we've sent you the due process policy that governs the medical staff, and all of Dr. Harmon's due process rights within that organization, and they are substantial. The medical staff has a huge discretion to do whatever they want, right? They can look at this as long as they're acting in good faith. The medical staff's going to say, there's nothing to see here. We don't even need to hear from you, Dr. Harmon. Or they're going to say, Dr. Harmon, come talk to us. And if they don't like what they hear, they are going to make a recommendation. And that recommendation can go a million different ways. It can be, you need counseling. It can be, we want you to go to this seminar for, professional behavior by physicians to teach you how to deal with conflict resolution in a high stress environment, which is what you work in. Or it can say, this behavior was so beyond the pale that we don't think you belong here. And we, the medical staff, are making a determination that your conduct does not meet our standards and we're taking your privileges, or anything in between there. And if it's something that limits her privileges in any way, she gets a full evidentiary hearing in front of her peers, physicians on the medical staff. And only after that does it then go, whatever the recommendation of that peer review panel is, will go to the medical executive leadership, and they will either decide to adopt it change it or do whatever. And then that can go to the board of directors. And then after that, she can sue the hospital for the results of that peer review action. And that's when malice and immunity gets tested. It's in that construct. What she doesn't have is a claim for intentional infliction of emotional distress, I think, as a matter of law, based on nothing more than the hospital saying to the medical staff, we need you to review this physician's conduct and tell us if you think it's appropriate, because you are the body in this organization that makes those determinations. Because we have no privity of contract with Dr. Harmon. Our administration cannot dictate her conduct or punish her or fire her. We have none of those remedies. That all has to come through the medical staff. And so that malice only attaches in that analysis to when the medical staff has actually done something, which it hasn't. So we're being sued just for telling the medical staff, look at it, because we are very unhappy with this physician's professional conduct, and we need the medical staff to tell us whether it agrees or not. So I don't think we can establish a body of law in Georgia where a hospital merely doing that, sending it over to the medical staff and starting the process, just the petitioning act, not even taking action, can be used as a predicate, factual predicate for an emotional distress claim. But I don't want to get hung up on this, because I don't even think you need to get to a bright line rule here, because we think even if the court doesn't view this issue that rigidly, on the facts of this specific case, it must be apparent to the court that these plaintiffs cannot reach that threshold of outrageous and extreme behavior for 3 factual reasons. Number one, I think on its face, Dr. Weinstein's alleged conduct, which is at the heart of her claim, and I'm talking about the alleged OR altercation, that conduct, even as alleged in the complaint, was certainly unprofessional, but cannot be said to be so extreme and outrageous as to support an IIED claim under Georgia law. Number two, and we believe this is key, if you just look at the allegations of the complaint alone, which is a very self-serving complaint, even as self-serving as it is, the complaint confirms that Dr. Harmon participated in both instigating and exacerbating the underlying altercation. And she was also unprofessional in that encounter. And we will submit to you that you cannot claim intentional infliction of emotional distress and prove something was so extreme and outrageous that you are a part of instigating and participating in as a matter of law. And you are empowered at this stage of the litigation to make that determination, both on the anti-SLAPP motion and on the 12b-6. The Court of Appeals has told us repeatedly this is an issue of law for the court to decide at the front end, because otherwise anybody can just claim, outrageous distress at any kind of stressor event and get into expensive litigation and discovery. And that is not the standard for that claim under Georgia law. And then third, Dr. Harmon's post-altercation conduct was also unreasonable, unprofessional, and most important, disproportionate, and entirely non-compliant with the rules and policies governing the medical staff and conflicts between medical staff that she was duty-bound to follow, but failed to. She can't ignore what she is legally obligated to do to resolve conflicts on our medical staff and then come to court and say, but it was so outrageous, so extreme, when she did nothing to follow the protocols and policies that she told us she would as a condition of her privileges. So with that factual context, which is proven by the verified allegations in the complaint, the ruling of this court's family division denying Dr. Harmon's petition for restraining order against Dr. Weinstein, which you do have in the record, and the affidavits that Northside submitted with its motion, we don't believe the court can properly find that Northside's request that the medical staff review her role in all of this, again, as required by law and consistent with the bylaws and the policies directing those matters to the medical staff, we don't think that can support a claim for outrageous and extreme conduct as a matter of law. Now, if it's helpful, I can walk you through that evidence very quickly.
Okay.
I promise to be as concise as I can be. First, the plaintiff's own allegations in the complaint. And again, while of course it's drafted to reflect Dr. Harmon's unique view of the altercation, to credit it, it does acknowledge what started the altercation. And I can share my screen and show you the provisions I'm referring to, or I can just direct you to them, whatever your preference is.
Seeing it is helpful as long as it doesn't, as long as it's easy enough and can be done efficiently.
It can be done efficiently. So let me jump forward if I can share my screen here. Do I need to ask no, I don't.
Nope.
One moment. All right. Your Honor, are you able to see my screen with the complaint?
I am.
Okay, terrific. Let me, if we go, the paragraphs that I'm going to focus on are paragraphs 91 through 109, which are the key paragraphs describing the beginnings of that altercation and the aftermath. And I've highlighted them, and I'll try to make them as big as I can here. So starting on paragraph 91, here's how she has even described what started all of this altercation. So what started it all was Dr. Harmon's frustration that Northside could not add a case to the end of her already crowded caseload on Friday, December 20th, 2024. So these facts are taken, the ones I'm going to refer you to from, again, paragraphs 91 to 109 of the verified complaint. And I'll add a little context that I think Dr. Harmon would have had to acknowledge if she were cross-examined today, but I'll tell you when I'm adding context. So paragraph 91, she sent her request. This came the night before, but she sent a request for the case to be added on Friday, the day before. What she omits from the complaint, Your Honor, is that she submitted this request by email to the surgery center administrator in the evening before, well after the surgery center's business hours were closed. She had only one operating room assigned for Friday, and that schedule was packed. So paragraph 92, what she's acknowledging here is that Northside tried to accommodate her request, but she omits that Northside actually gave her a second operating room to use so she could work simultaneous cases in an effort to see if they could fit this case in. And that went on through the morning, and sometime around noon, and this is now midday, paragraph 92 is where we're talking now. About midday on Northside had, on that Friday, Northside had determined that the additional case was not going to be able to be accommodated. Now, Dr. Harmon very much disagreed with that assessment. And let me take you forward to, because 92, 93, and 94 are reflecting that Dr. Harmon and Northside Surgery Center Administrator at the time, Joe D'Agostino, were in pretty regular communication throughout the morning about whether this was going to happen or not. And he told her about midday, and this is where paragraph 95 picks up, that we're not going to be able to do it here. Now you'll see what she says at the end of her allegation in paragraph 95 is, now Northside's administrator, this is important, not Dr. Weinstein, but Northside's administrator has told her we're not going to be able to do this. You might want to take this case somewhere else because Northside can't get to it today. And Dr. Harmon's view is there was no valid reason for Northside Surgery Center administrator to think that. And this is an important allegation to point out, Your Honor, because she's telling you why this altercation started. She was frustrated. She was angry. She wanted the case on, and Northside told her after efforts to accommodate her, including giving her a second OR, that it wasn't going to happen, and she didn't buy it, and she was angry. And so she started questioning the surgery center administrator, this is paragraph 96, about why they couldn't do it. She was contesting Northside's decision that it could not accommodate the additional case despite its efforts to do so. And as you see here in paragraph 96, she says she was continually advocating for her patient. She informed Mr. D'Agostino of the negative health impact of such last-minute cancellations. She was fighting with the surgery center administrator, Your Honor, about the decision not to put her case on. So then, paragraph 97, she tells you how she feels about it because Northside called the patient's parents and said, we're not going to be able to do this today, which she now says she believes was false. And she says this resulted in the parent's deductible for the patient resetting, further delaying the procedure, and she's mad about this. Paragraph 98, she tells us who she blames for it, and it's on information and belief. Now, she's just had a patient be told, as she alleges in this complaint for the second time, we're not going to be able to get to your surgery when she has told the patient she's going to do it. because Northside couldn't accommodate it. And she says, upon information and belief, Mr. D'Agostino made the decision to cancel the patient's surgery at the request of Dr. Weinstein. So she is blaming Dr. Weinstein, not because she witnessed anything he said or did, on information and belief, which to her credit, what she's telling us in this allegation is, as soon as Northside Surgery Center told me they're not going to do this and it canceled that procedure, I blame Dr. Weinstein. And so this is important because this is what started it all. Paragraph 99. So, by the way, the rest of this paragraph 98 is Dr. Harmon's recitation of her view of her disagreement being articulated to Mr. D'Agostino, the surgery center administrator. She was very angry. She believed that Dr. Weinstein had influenced him to do what was not right, and she was letting him know in a meeting in his office when in paragraph 99, Dr. Weinstein came in and interrupted them. And according to Dr. Harmon, while she was giving the surgery center director the business for not allowing the additional case, Dr. Weinstein came into the office and said, hey, you need to go see your patient out in the waiting room who hasn't been pre-oped so we can get this case to surgery. And she told him, I already did it. Now, in Dr. Weinstein's version of events, which the court will have at some point, perhaps, hopefully not, but she called him a liar. He got upset. But either way, she told him, I've already done it. And he said, no, you haven't. And she said, go out there, and this is all right here, where she tells him, you go to the waiting room, paragraph 99, and confirm that Dr. Harmon had spoken, that I've spoken to my patients. And he said, no, you need to go do this. And she says, I've seen them. Now we're on paragraph 100. I've seen them, and she walks out of the room. So she's hot. She's telling the surgery center administrator she's angry about the surgery cancellation. She tells us in her complaint she blamed Dr. Weinstein for it. Dr. Weinstein interrupted that conversation, and she reacted to him negatively, and he reacted to her negatively. But that's where the altercation started. And then when we fast forward a few paragraphs, you'll see, paragraph 101, shortly thereafter, after initiating anesthesia on the last patient for the day, so this is maybe a couple hours later, her last patient. And Dr. Weinstein is the anesthesiologist who's treating this patient and putting this patient to sleep. So he has a medically necessary reason to be in that operating room with her. He is not going in there solely to agitate Dr. Harmon. He's got a reason to be there. He is angry. He is frustrated. He's tired of her. She's describing that here. But at one point, after administering anesthesia, now we're up to paragraph 103, he comes back in paragraph 104 while she was operating on the patient, which he has to do as the anesthesiologist to periodically check on how the patient's doing. What she alleges here is, I think he came in more quickly than usual, which is telling you already she was on edge and alert and not happy to see this guy. And he comes into her room and he says to her, according to her own allegations, this is paragraph 105, did she say something? Did you say something to me? She says, alleges, because she had not, Dr. Harmon responded she had not said anything to him. In response, Dr. Weinstein exclaimed, what did you say? And this is important, Judge. I want to focus you on this. He is asking her, did you say something to me? She said, no. He said, what did you say? And instead of saying, Dr. Weinstein, I don't have time for this right now. I've got to do this patient. We can talk about this later. Or is there something we can address later? Or anything else to de-escalate an already hot situation between both of them. This is what she says to him, admittedly, her own version. She says, while she's in the middle of surgery, since you want to talk, let's talk about how we just affected a child's care and that mom will have to pay another $12,000 deductible, referring to the patient whose surgery was not able to be put on the schedule. And she attributes to now being twice delayed by Dr. Weinstein's machinations. Judge, she went after him. She baited him. She knew he was in there upset already, primed for an argument, and she baited him, which she acknowledges achieved its purpose in the next paragraph, 106. He cut her off and shouted, you're always acting like you're getting effing persecuted. And Your Honor, we were off to the races at that point. So her own characterizations of, I can stop sharing now if I can figure out how to do it. Here we go. Sorry about that. So, Judge, I'm sorry for the enthusiastic presentation of it, but you needed to have, and these are her own words, her own description, a very one-sided description of the altercation. But what she's acknowledging is that she participated in the instigation of the event. And I submit to you that just as a matter of law, you cannot be someone who is a willing participant, even if just at the beginning of the incident, that then you turn around and say, my reaction to this sparked his reaction, and it was so extreme and outrageous that I get to claim emotional distress for it. That is not how this tort works under Georgia law. You can't be the instigator and then claim to be the victim at the same time. Now, things obviously escalated from there, including Dr. Harmon calling police to the surgery center, going to this court, family division, seeking a restraining order 3 times. I think this is all in the record, but she went the first time and then didn't show up for the hearing, so it got dismissed. She filed another one and it got rescheduled, and then she filed a third one. In one of those, she did, it must be the third one, I believe, she did get an ex parte restraining order. And then once Dr. Weinstein was served, which by the way, she served him process at the surgery center during patient care hours, which the hospital was very unhappy about for obvious reasons. She did have a hearing, and this is also in the record, and I'll show it to you in a minute, in front of the family division of this court.
Judge
And
Manning?
Sorry?
It was Judge Manning. She typically handles our
It
TPA.
was not, it was Jesse Law.
Okay.
Who's sitting by designation.
Mhm.
And I'll show you her decision in a few minutes on the back side of this argument. But all of this was, in Northside Hospital's view, unprofessional and non-compliant conduct by Dr. Harmon in reaction to what should have been, an unfortunate, unprofessional altercation between 2 physicians on our medical staff, and has now been turned into something very different. But it didn't stop there. She submitted a complaint to the composite board, which is the licensing board for physicians, accusing Dr. Weinstein, who again is an anesthesiologist on the medical staff and employed by Northside Hospital, of patient misconduct from years before that Dr. Harmon had no firsthand knowledge or validation of, which then prompted a legal investigation by the board, including of Northside Hospital's records regarding any such allegations. That was all, by the way, after Dr. Weinstein had his medical directorship stripped by Northside Hospital, his surgery schedule reassigned so that there was no interactions between him and Dr. Harmon, and cost him a fair amount, and counseling by the hospital. And then on top of all of this, she demanded that Northside pay her millions of dollars, and also at the same time requesting that Northside increase her block time on threat of litigation. And I'll explain what block time is in just a minute. So that gives you the flavor of Dr. Harmon's own participation in all of this, and why Northside Hospital feels very strongly that based on her own conduct and admissions, she cannot possibly carry the burden to show extreme and outrageous conduct directed at her that is actually actionable. So again, Northside had no privity to take action against Dr. Harmon. Because Mr. Boyd and Dr. Harmon in their filings submitted to you some of the pre-litigation correspondence between me and Mr. Boyd that referenced the disciplinary actions that Northside took against Dr. Weinstein. So that is in the record. And we didn't have the ability to counsel Dr. Harmon or reprimand her or demote her or change her schedule, or most importantly, cancel her medical directorship. She doesn't have one with us. So we didn't have any mechanism to deal with her side of the unprofessional behavior. That's what the peer review process is for. I will tell you, because this is also in the record, she did reach out and ask Northside for a tolling agreement. Part of her response to the anti-SLAPP motion was, Judge, they waited, in her affidavit in opposition to this motion is the peer review process didn't get initiated until December, a year after this incident. Well, after she threatened to sue us, she asked us to mediate with her first. And it took us almost 8 months to get a mediation scheduled with a mediator that both sides would agree to. And they asked us for a tolling agreement, and we gave it to her. So Northside made every effort to try to negotiate a resolution of all of this with her. And candidly, Northside's preference for the resolution of this is that she take her patients elsewhere. That mediation failed. Her demands have escalated. And so Northside pulled the only lever that it has to address what it perceives to be unprofessional conduct by a member of its medical staff. And it sent it to the medical staff for review. And it only did that after it became abundantly clear that there was not going to be a path to resolution amicably with Dr. Harmon. So that's the only mechanism Northside has to protect itself from any of this conduct. And it's precisely the mechanism that she agreed would be utilized to hold her accountable for her behavior at the hospital. So I'm going to show you very quickly the source of those obligations so that you have them. So let me share again, if I may. So we are going to look at Miss Alfonso's affidavit, which was shared with you as an exhibit in advance per your standing order. But I can also show it to you on the screen if that's helpful to you.
It is.
So let me go to page 101 of this PDF. So this is Exhibit F to Miss Alfonso's affidavit. These are Northside Hospital's medical staff bylaws. What I want to direct you to is on page, well, it's 108 of the PDF, but it's Article 2 of the medical staff bylaws. This sets forth the purpose. You'll see that this provision provides that the entire staff privileges structure is intended to foster that self-governance by the medical staff that I talked about, specifically including accountability. You'll see that in this paragraph 5, that the purpose of these bylaws, again, adopted by the medical staff themselves, is to set up the organizational framework for the self-governance of the medical staff, which defines the responsibilities, authority, and accountability of each organizational component and individual member of the medical staff. So basically, that's saying non-employees get, if you're on the medical staff, you're not employed, this is the mechanism. So next, I want to go to Article 7 of these bylaws. Which are on page, looks like they start on page 15. This tells you that privileges are subject to medical staff policies. Staff membership confers privileges, but only as stated in these bylaws, the credentialing policy, which you also have, Judge, and the other policies of the medical staff. Article 12 starts on page 32 of the medical staff bylaws. This says, again, this delineates the procedure. I want to look at 12.1. This says we're going to have rules and regs that govern medical staff. They are binding on all staff members. If you go to 12.5 on the next page, policies and procedures, particularly B, policies and procedures of the medical staff are intended to provide guidance and accountability and are not intended to define or alter recognized standards of care. And the reason I highlighted that for you, Judge, is because this is not the medical staff saying these policies tell you how to practice medicine. These policies tell you how to behave in our hospital. And then it says failure to comply with those policies may result in disciplinary action under these bylaws. That's if you go to the peer review process. We're going to skip forward 2 pages to page 34 and Article 14. These are very important provisions. Section 14.2, Your Honor, authorizations, and conditions. By applying for privileges, exercising privileges, or providing specified patient care services at our hospitals, a practitioner, and let me skip down to paragraphs 3 and 4, first says they're going to be bound by the provision of this article, and they are going to waive all legal claims against any representative who acts in accordance with this article. And 4, acknowledges that the provisions of this article are express conditions to his or her application and acceptance of privileges, continuation of privileges at our hospitals. So these, and I'm going to show you where you're supposed to send all this stuff to peer review when you have these kinds of conflicts. She agreed as a condition of privileges that if we did that, she wasn't going to sue anybody for doing it. But here we are. So section 4.14.3, immunity from liability for action taken. No representative shall be liable to a physician for damages or other relief for any action made within the scope of his or her duties as a representative if they act in good faith, without malice, within the scope of his or her function, has made a reasonable effort to obtain the facts, etc. That is the standard, by the way, under both the Georgia peer review and federal immunity for peer review activity. It's just memorialized in the bylaws as well. And she agreed to those immunity provisions. This section 14.4 says the activities covered by this include all information and is not limited to corrective or disciplinary action, including suspensions. In other words, if we send you to peer review for disciplinary action, and this is also paragraph 11 here, other hospital or staff activities related to monitoring and maintaining appropriate professional conduct, all of these provide express guidance to Dr. Harmon, and she agreed that this is how we're going to deal with issues involving appropriate professional conduct. That's in our bylaws. I can move on to Exhibit B in Ms. Alfonso's affidavit. This is the medical staff code of conduct, one of the policies adopted by the medical staff to govern their own behaviors. This describes disruptive behavior and inappropriate behavior. It very much captures what is alleged that both of these practitioners engaged in, including under disruptive behavior, any abusive conduct, forms of verbal or nonverbal conduct that harms or intimidates others. Inappropriate behavior includes demeaning or offensive behavior. It applies, I can show you here at the bottom, to both, and I'll go back up. It applies to everyone, employed and privileged practitioners. So what does this policy say they're supposed to do? Well, the first thing it says is disruptive behavior, if that's what this is, should generally not be resolved informally. If the affected individual elects to communicate and interact directly with the practitioner, the occurrence and resolution should be reported through the incident reporting system to ensure appropriate trending. The incident reporting system, Judge, is peer review. It goes straight to quality improvement in the medical staff. And for trending, that's because the medical staff wants to know when there's disruptive behavior between doctors. And this tells you if you're going to do it, we don't think you should be trying to resolve it informally. Come to us on the medical staff. Let us help. But if you're going to do it, you still need to report it so that the medical staff can handle it. Reporting the occurrence. Paragraph 2 says, you're supposed to send this through an incident report quality improvement referral pursuant to the administrative policy E-001 incident reports-QI referrals. Any practitioner who observes such behavior may complete an incident report or notify the chief or vice chief of the medical staff or the department or section chairman or vice chairman. Doctors, if you've got disruptive behavior, go talk to your elected medical staff leadership or file it in the peer review process. Paragraph 5, medical staff review and disposition. This tells you where this is supposed to go. It's supposed to go to the appropriate medical staff department or section chair for review. And what they can do is refer it to a departmental peer review committee, which in this case would be the surgery peer review committee, or refer a report of disruptive behavior to the Professional Relations Committee. And the reason I've highlighted that, Judge, is because the Professional Relations Committee is a standing committee of our medical staff that does nothing but deal with disruptive physician behavior. That's all they do. And this policy says that's where this is supposed to go. So this just lays out the rest of, and here paragraph 7 tells you what I just said, that this is a standing committee that is supposed to help deal with disruptive physicians. If you see down here, subparagraph B, the role is to counsel practitioners regarding behavioral concerns, provide a forum for discussion between the involved parties, investigate and mediate the dispute, all under the peer review medical staff rubric. That's how she is obligated to resolve her inter-medical staff disputes. She didn't do it. So I don't think we need to walk through them, but I'll just tell you quickly, you've got Exhibit A to Ms. Alfonso's affidavit is the conflict management policy. That also directs medical staff to escalate interpersonal conflicts through the peer review process to either the department chair or that PRC committee. Exhibit E is the credentialing and due process policy. We gave you that just so that you would have it, if you needed to, reference Article 7, which gives Dr. Harmon her day in court, so to speak. If the medical staff believes any action is necessary, she has due process rights. She can explain all of her complaint and grievances to her peers on the medical staff. And if her behavior was professional and appropriate in their determination, then she's got nothing to worry about. But that's where her grievances had to go for this. So again, we think the complaint shows unequivocally that she was a willing participant in the altercation she's claiming caused her distress. We think she escalated it improperly and unprofessionally, and more importantly, in violation of her duties under the bylaws and medical staff policies she agreed to follow. You have it in the record, but let me just show you real quick Judge Law's treatment of this same issue. So this is Judge Law's dismissal. You've got the affidavit in the record that Dr. Harmon submitted to the Family Court Division in support of the petition. It's more or less the same story she's told in the complaint. Northside had at least two representatives present in the courtroom for Dr. Harmon's hearing on this motion. The court, Jesse Law, Judicial Officer Law, made this decision after hearing from Dr. Harmon and having her affidavit. Dr. Weinstein was subpoenaed and required to be present at the hearing. She didn't ask him a single question. She didn't want to hear a word from him. She dismissed this without even talking to him and said, effectively, this is not a good use of judicial resources. You guys need to act more professionally. She acknowledged that Dr. Harmon had instigated a misdemeanor complaint against Dr. Weinstein, and she expressly acknowledged in the order that Northside had already issued a memo that the parties are not to work in the same operating room, and she dismissed this for failure to meet the standard of proof. So that is the factual context for plaintiff's burden to show you that the peer review referral was so extreme and outrageous as to constitute intentional infliction of emotional distress. So we respectfully submit, again, Your Honor, that on these facts, she cannot carry that burden, whether it's based solely on the alleged peer review referral or all of the other conduct she alleges was actionable. We don't think she can carry that burden on this claim, regardless of what the factual predicate is. And it has to be stricken. And if you'll indulge me, I got a little bit more to go.
Yeah, well, you've
Your
been
Honor.
going, I've got a timer going. You've got about 7 more minutes before you hit the 1 hour mark. So
All right, I'm going to speed through this. That's only the first half of what she has to do to avoid being stricken here, because she not only has to prove that the conduct was so extreme and outrageous, she's also got to prove that her injury was proportional and severe enough and proportional to the actual conduct, and she can't do that. So that's why we asked you, by the way, for discovery to have her produce her medical records and an expert medical diagnosis that the severity of her distress had been medically diagnosed, which is what the complaint certainly suggested. we're not going to show you any of it because we're on YouTube and I don't want to put any of that information out in the public's eye, but I believe you have it. If not, we'll get it to you. But they produced no medical records at all. They produced an affidavit of a psychologist who's not a medical doctor, um, but a non-medical therapist who cannot prescribe medicine. And even then, they did not produce any admissible qualified expert evidence of medical diagnosis or causation for emotional distress. They did produce what I think was an exceptionally self-serving affidavit from Dr. Harmon, describing what she claims are panic attacks every time she comes to Northside for procedures, and of course, on which she declined to be cross-examined at this hearing. And I want to take just a few minutes to show you why I think that is. So, as you know, she has, oh, I closed Ashley's affidavit, Ashley Alfonso's. I need to reopen that because I need to show you one more thing on that. So, you know, she's claimed she's lost millions of dollars in revenue as a result of all of this. But the numbers don't lie, Your Honor. Her utilization of Northside Surgery Center has only gone up and up and up since the altercation she now claims has effectively paralyzed her and gravely wounded her medical practice, which again, she is under no obligation to bring to Northside, but she continues to do it in high volumes. So if I can share one more time, and I will move quickly through this. This will not take long, I promise. I'm going to show you some of the business records from Northside Hospital that were authenticated in Miss Alfonso's affidavit. I'm going to start with this, which is Exhibit C to her affidavit. This is Northside's surgical block scheduling and management system policy. It starts by telling you, Your Honor, block time is not a privilege guaranteed to any physician member of the medical staff. Hospital administration has the sole discretion to grant, remove, or adjust block time for any physician based on a determination that it is in the best interests of the hospital and its operations. So block time, Your Honor, is a non-guaranteed privilege. And I'll stop sharing until I come back to this in a minute. It is a non-guaranteed privilege offered to high utilization surgeons at Northside's discretion. It is obviously an advantage for a surgeon because it gives a surgeon exclusive use of one or more operating rooms on a set regular schedule. Dr. Harmon has for many years enjoyed block time at one of Northside's surgery centers. Specifically, she gets 2 operating rooms for her exclusive use, 2 days, every other Wednesday per month. And on months that have 3 Wednesdays, she gets a fifth, she gets that 5th Wednesday, a 3rd day. Per the policy, she has no right to that block time. And it is, I should have shown you, but you've got it in the record. Paragraph 3 of the policy makes clear that it is contingent on compliance with medical staff bylaws and policies. In fact, it's the very first criteria that the hospital uses to evaluate whether to offer a surgeon block time. And to be clear, no matter how high volume you are, even if you comply with the medical staff rules, you don't have the right to it. Hospital retains absolute discretion on how to award block time in order to safely and efficiently operate its facilities. So, the fact that Dr. Harmon still enjoys block time at Northside today, despite what I believe is her extremely aggressive adversarial posture with the hospital at this juncture, means she is not oppressed at Northside. She is exceptionally privileged because she is one of a remarkably small number of surgeons that actually has block time, as opposed to being in what I would call gen pop with the rest of the surgeons who've got to basically fight to get on the schedule. And that's not ideal. And despite the pendency of this litigation and all that has come before it, her block time remains intact. Northside hasn't terminated it, even though it could. So I can show you, I will show you real quick just so we can get this over with. I'm going to show you her volumes so you can see exactly how distressed her practice has been since the altercation. We also filed an affidavit of our paralegal, Stacy Delk, who, just so I could have this fact proven in the record for you, this is really not controversial, but these are Dr. Harmon's medical staff privileges. every physician has to publish them on their Georgia Composite Medical Licensing Board profile. And so we just pulled this down, and the affidavit provides legal authentication of this website information, even though I don't think it's controversial and it may actually be admitted in the complaint. But the point is, Dr. Harmon doesn't just have privileges to take her patients to Northside. She also has privileges at Wellstar and at all of the Children's Healthcare of Atlanta facilities, of which there are many, as our Wellstar also has many facilities. And this is relevant, Judge, because she has other places to take her patients. And as I'm about to show you, she's not doing that. So let's look at Exhibit D to Miss Alfonso's affidavit. If I can get it open. So this data is from a mandatory state database called the Georgia Discharge Data System that Northside Hospital and every other hospital both reports into and utilizes in the regular course of its business. Every surgery at any hospital or surgery center must be reported by law to the state on a monthly basis, so the state can track utilization for, among other reasons, certificate of need evaluation. So how many and where surgeries are performed by any surgeon licensed in practice in Georgia is readily ascertainable from this database. And what this data is showing you, Your Honor, is that since 2023, when Dr. Harmon claims Northside and Dr. Weinstein started interfering with her practice and causing her extreme emotional distress, her volumes at Northside have only gone up, and her utilization of other facilities where she's privileged has gone the other direction. In other words, despite her claimed extreme emotional distress, she's moving more of her practice to Northside, not less, during the time how horribly Northside is treating her. So, Your Honor, I would submit if emotional distress were truly what Dr. Harmon represents it to be, if her emotional distress is, she would be looking to take her patients somewhere she feels safer. And what is particularly notable here, what you don't see on this data chart, Your Honor, is that despite that she has privileges at Wellstar facilities, and she's had those privileges for some time, she has done 0 procedures there. To be clear, it is not that her procedures at Wellstar facilities are just not reflected on this chart. They aren't here because they don't exist. She is not using her privileges to take patients to Wellstar's facilities at all. So what we offer that the court should take away from this evidence is that Dr. Harmon is not a hostage to Northside. She has many other options to take her patients. The objective and indisputable data tells a very different story than her strident allegations to the contrary. She is not retreating from her alleged persecutor. She's doubling down on her relationship with Northside. And I just want to point out, fiscal year to date, 2026, she has 99 cases at Northside Surgery Center through January alone. Your Honor, she is on pace. She's on a record pace at Northside. She is annualizing at about 400 procedures at Northside Surgery Center, which is about 30% more than she's ever done at any of our facilities in the past. And she's doing that at the same time that she is costing Northside, or claiming Northside cost her millions of dollars by not giving her more time and access to our facilities that she has no legal or contractual right to have. So with respect, even setting aside the lack of legal merit to the claims here, there are some serious credibility issues I would submit with her evidence, and the court needs to take critical note of that. So the only other 2 things I want to show you, and I won't linger on them, I just want you to know they're there, are these other data points that we submitted for you. One of them is Exhibit G to Miss Alfonso's affidavit. This is internal Northside business record utilization report. So this isn't the state database. This is just Northside procedures. This one shows that since the incident on December 20th, 2024, when she's not on vacation, Dr. Harmon's utilization has not skipped a beat. And if you go to the next exhibit, Exhibit H, which is just we switched to a different medical record system. So this comes from a slightly different view, but this is from August of 2025 through the end of April. And again, what you can see from this evidence, Your Honor, is she's on a record pace. And since the peer review referral in December, when she claims her emotional distress got exacerbated by the mere referral, she's been on a tear, more productive than ever. So that is it. That's the evidence we wanted to make sure the court had the benefit of. I know it was a lot, but we think it shows that Dr. Harmon has no legitimate likelihood of success on her IID claims. We do ask the court respectfully to grant the anti-SLAPP motion, strike and dismiss the IIED claim altogether on this evidence. And we do thank the court for your patience.
Thank you very much. Mr. Boyd, your response. And you're muted, first of all, which it would not be a Zoom hearing if I didn't have to say that at least once.
Thank you, Your Honor.
Number one. Number two, Mr. Boyd, start by telling me if Mr. Bauer's answer to my question, limiting the scope of the 9/11/11.1 motion from Northside Hospital to the IIED claim based on, and really to the extent the other claims might touch on it, but any claim essentially that is derived from this peer review process.
Yes, Your Honor.
Start by telling me why that would not be petitioning activity as contemplated by that statute. Because if you don't disagree with that, then I think we spend our time better focused on your opportunity to respond to all the facts that have just been laid out by Mr. Bauer.
Sure. And Your Honor, we do. What we just saw was effectively a jury argument without evidence against the standard of review that this court has to apply, which is to take all inferences in the favor of the plaintiff. Shoehorning in arguments and even facts that are nowhere in the record. The anti-SLAPP motion is limited solely to the referral to peer review. And we just heard lots of arguments based upon everything else, which don't have any relevance to the court's review of this particular issue. And as we pointed out in our brief, this intentional infliction of emotional distress claim survives even without the peer review referral. It is cumulative. It is retaliatory. And I think Mr. Bauer admitted it was such in his presentation. It is done with malice, as we have pled. And therefore, we are perfectly entitled to use it in addition to all of the other things that have happened to Dr. Harmon, instituted by Northside, or Dr. Weinstein, or them together. And so it's a much, much narrower issue than what we just heard. We did not need an hour to discuss that. We did not need arguments about utilization that have nothing to do with this. And I will digress, Your Honor, and I apologize for doing it, but what that information doesn't show was how much she was working beforehand. And that's the crux of our argument. Not that she's not getting block time at all, but the difference between the two. And we think we'll be able to prove that ultimately at trial. But at this stage in the game, under 9/11/11.1, it does, as Your Honor noted at the very beginning, incorporate effectively a 12b6 standard. You've got to take all of the well-pleaded information available in the complaint and the supporting affidavits from Dr. Harmon and her treating physician, and construe that in a light most favorable to them. And so when Mr. Bauer goes to the complaints and talks about Dr. Harmon being, I wrote these down, mad, hot, frustrated, that is nowhere in the complaint. Doesn't exist. Made up. He talks about you assessing credibility issues in this context. That's not the appropriate scope of Your Honor's review in this context. And so what we've got is the very limited issue of whether the Northside's referral to peer review with the evidence in the record is actually protected activity. It's our view that the intentional infliction claim would survive even without it, but we also should be able to rely upon it. And this is why. First of all, the complaint is verified. Every allegation in the complaint was made under oath by Dr. Harmon. She's also submitted her own affidavit, principally looking at her emotional distress, plus the verification from her treating psychologist, which was sort of denigrated as not being a medical doctor when she's got a doctor of psychology and is a treating clinical psychologist for the last 14 years in the state of Georgia.
Well, let me stop you for a moment, Mr. Boyd. So the very recent case of Emory Healthcare versus Harms, which still doesn't have even a Southeast Second
Right.
designation. And I had to go down a rabbit hole because it's got they substituted an opinion. I have no idea why. But I mean, it clearly says that peer review proceedings are official proceedings. And so why are we even having an argument about that first part? Why are we not just focusing our efforts here on your argument that Dr. Harmon can survive a 12B6? And therefore, the case shouldn't be, the IIED claim shouldn't be dismissed based on 9/11/11.1.
Sure. I'll take the second half of that first.
Sure.
The only part that could be subject to dismissal under 9/11/11.1 is the referral to peer review, not the claim in total. So if we're looking at only that limited piece of it. But more importantly, we don't disagree. Now, when we filed the complaint in January, Emory Healthcare hadn't been decided yet.
Of course, yes.
New development. But
Thank you, Judge Watkins.
That's
Or
right.
Judge Doyle. I don't remember which one, but
But that case does say that a peer review process
Mhm.
is subject to the statute. We don't disagree with that. The question is, do we have here the type of thing the type of activity, and do we have a peer review process yet where the actions can be protected? In Harms, the individual who was being reviewed in the peer review process was already in the process. And the things he was challenging was the submission, I think, of psychological, it was a test to see whether he was fit to be practicing medicine at the age. So we're already in the process at that time. And, again, subject to what I'm going to say about malice later, if it were a normal peer review process, we would agree, I think, that what happens within that process is going to be protected, and we won't be able to use it.
I guess, and I understand your distinction, right? That when I read the complaint, I understood Dr. Harmon's allegations of intentional infliction of emotional distress against the hospital to be both this instigation of this review or reporting of her to this board, but also some derivative or vicarious liability of the hospital because of Dr. Weinstein's actions, or potentially because of their own actions. That's a little less clear to me, that part, that direct liability part that isn't related to peer review. And I guess my point is, if we're in agreement that what we're talking about right now on a 9/11/11.1 is the instigation of the peer review, then to me, it's not really an open question that if the peer review process is an official proceeding for purposes of 9/11/11.1, then necessarily the referral to that peer review process has got to be part of it, number one. And if that's true, then I understand your argument about malice, but isn't that really an argument that she can succeed on the merits potentially, in spite of these arguments and claims about immunity, and therefore you succeed on that second prong?
It's kind of both. I mean, if we look at 9/11/11.1, specifically subsection C, our point here is that the mere referral of Dr. Harmon to peer review for retaliatory purposes, one, is not addressed in Emory Healthcare in Harms, and it is not protected. You've got to look at C1 and C2, and that makes clear. C1 says that this is the protected part. Any written or oral statement or writing or petition made before a legislative, executive, or judicial proceeding. We don't have that. Mr. Bauer confirmed, and again, I wrote this down because it is very important, that, quote unquote, all that happened is the request. There's no actual peer review activity. Those were the two things he said in his argument, and that we agree with. It's true.
Yet, right?
Yes,
Isn't
right.
the necessary inference there yet?
Yet, right. And like I said, there's a distinction between a malicious referral, which is what we have here, and what happens within the actual proceeding once the referral is made. And like I said, we might agree. Again, I think that there might be an argument to be made if it's malicious, like we say, even that might not be off limits. But for purposes of this argument, we would probably agree that once you're in there and once you have witnesses testifying about what happened or providing information what happened in writing, for example, which goes to C2, that might be protected. But the referral itself, and again, remember, Northside's judge, jury, executioner here. It's purely internal. They cited the.
I'm sure Northside would say it's not them that's judge, jury, and executioner, right? It's the 4,000 doctors that all work there.
Right, but I mean, it's their organization.
Sure.
Yeah, and so it's different. They cited in one of their briefs, I think at the Giordano case, that Giardardi, excuse me, versus Bowen, completely inapposite. That involved a customer of a tattoo artist.
I was just going to say, is that the tattoo?
Yeah, it's the tattoo artist
Yes.
case. Yeah, it doesn't address this. And if you read the anti-SLAPP statute in pari materia with the immunity statutes for those procedures, which I think you have to do because they're at least related, there is not a get out of jail free on immunity if the proceeding is instituted with malice. And if you look at C1, it says a written or oral or statement or writing or petition made before the proceeding. C2 says any written oral or statement or writing or petition made in connection with an issue under consideration or review by the official proceeding. As
What
Mr. Bauer said.
So what about so that case, Judge Watkins discusses by analogy, the state bar, right?
Mhm.
And
Yeah.
the Jefferson case involved basically a situation like this, where I'm suing you because you made a complaint to the state bar. I mean, to me, that seems pretty akin. I'm just really struggling with the idea that once it gets going, it's an official proceeding, but before it does, it is not an official proceeding. And that seems to me to be a distinction without a difference, or maybe that's not the right metaphor I'm going for, but you get my point.
No, I understand, Your Honor, and I don't think there's any case out there that actually specifically addresses this.
No, I don't think there is either.
Yeah, which is why I go back to the plain language of the statute.
Mm-hmm.
You go to C1, you get to C2. It's an oral statement or writing made before a proceeding, meaning before the body that's hearing the information, or a written or oral statement or petition made in connection with an issue under consideration or review. So there has to be something happening in the proceeding itself under C1 or C2. And I don't think Northside alleges that any other portion of the anti-SLAPP statute applies here. And that makes sense because functionally it's a free speech statute. And what they want, if it is a matter covered by the statute, public policy behind it, is that people feel free to testify, to provide that information in front of the body.
Or to make a complaint in the first instance that would then lead to their testimony. And the only reason I'm pushing back on you so hard is, Mr. Boyd, I want you to be able to make whatever record you want to make, but I'm just telling you, it is unlikely that I'm going to find that the hospital's referral for a peer review or whatever we're going to call this analysis doesn't fall fairly squarely within an official proceeding for purposes of 9/11/11.1, but you might be able to persuade me that even if it does, Dr. Harmon's claims can still succeed.
Sure, Your Honor, and I've made my point. I mean, we're arguing the plain language of C1 and C2 for that first point, but I'll move on to the next. So it is just the intentional infliction claim, as I mentioned. The standard of review is to review the facts actually in the record. Which we heard a lot of things that are not in the record in the light most favorable to plaintiff. And it is very narrow. We don't need to be getting into, under this standard, the 12B6 arguments that were made regarding what happened with Dr. Harmon that's related to the tortious interference, defamation, assault claims that are not implicated by this particular motion. And the intentional infliction of emotional distress claims that flow from those other things. Narrow scope, it's only the peer review. And the question here before Your Honor is just whether we can include that too. So I would suggest to your honor that this is kind of a moot point already. I'm going to go through the evidence because we still win, or at least could win, at least pass a 12B6 standard based upon everything else. So the Northside's trying to strike the whole thing. That's completely inappropriate given the narrow scope of their motion, because only the peer review referral is even potentially protected. So that's number one. Two, we've got to look directly at the complaint and Dr. Harmon's affidavit, because we can now use that related to what happened here. And Your Honor, I apologize for this, because Northside's counsel went into this. I almost feel like I have to go back and talk about all the other things. But picture this. You're in an operating room. You're scrubbed in. You're operating on a child. And someone comes in and acts in such a threatening manner that you are fearful for your safety. All of the arguments being around that not being reasonable is based upon information that is not before the court and which you can't consider under any of these standards. What you've got to go with is what's in the complaint and what's in the affidavit. If I'm that child's parent, you don't think I'm going to say that behavior is outrageous? If I am responsible for the health and welfare of a child who's been opened up under anesthesia on an operating table, and I think somebody is going to come after me, that's not outrageous. The spin machine is very, very, very operational in Northside's briefs and in its presentation. And that's all it is. If you look at the complaint, and I've in our the attachment to our motion, response to the motion to dismiss, we have an appendix where we kind of group the allegations by topic, and I can share that here. But this is what we're dealing with. Hang on. Counsel talked about paragraphs 91 through 109. There's more to it than that. What we have, and we've bolded this because they tried to diminish it so much, violently and aggressively jumped in Dr. Harmon's face while shouting threatening statements, including using expletives, which I won't say here on the record.
Thank you.
When you get outside, this is going to be handled. Paragraph 179 says his demeanor was overtly threatening. 180, she feared for her physical safety. He refused to leave and aggressively paced around the room. This is not an anesthesiologist coming in and checking on the patient, as we heard. Again, that's nowhere in any record.
Well, I think in fairness, what I understood Mr. Bauer to be pointing that out for is that Dr. Weinstein was authorized to be in the room when this interaction occurred because he was the treating anesthesiologist. I agree with you that there's no facts here for me to be like, that's, that he came in to check on the patient. I understood Mr. Bauer to be saying he was authorized to be there.
Okay, if we're limiting it to that, I have no issue with that. Yeah, I heard it differently, but that's right. 183. Dr. Weinstein acted as if he was furious with Dr. Harmon and intended to harm her. Had the apparent ability to cause harm based upon statements, body language, tone of voice, knowledge that she could not leave the room because she had a child opened up on the table. Making threats he was going to take her ass out, take her blank out and to take it outside. And so that's what is in front of the court. If you go, and I'll stop the share, since we're in the 911 11.1 context, and we look at Dr. Harmon's affidavit, which again gets denigrated as self-serving, which again is not an appropriate review for the court under this current standard of review. Not to take the judgment out, of course it's self-serving. She's telling her story.
I don't have
Yeah.
any problem with saying it's self-serving any more than
Right.
Ms. Alfonso's affidavit is self-serving. It serves the interests of the party they represent. That doesn't mean it isn't also accurate.
That's right.
So-
And that is exactly the point. And oh, sorry, that's Dr. Abrams. I'll get to that in a moment. Picked the wrong one. Okay, can you see on the screen,
Yes,
Dr.
sir.
Harm? Okay. So, and again, this was done in response to some of the arguments made. Paragraph 4 talks about the component of emotional distress that is caused by the earlier defamation, which is again not the subject of the 11.1 motion. The emotional stress related to the tortious interference claim, which again, all of this is aggregate. It compounds upon itself. It's a series of activities over the course of some time. But then paragraph 6 is the acute moment, really. And when Northside is characterizing this as a passionate verbal agreement in argument, not with any kind of testimony on this, no record evidence, or calling it a heated workplace exchange, the affidavit conclusively demonstrates, at least for this purpose, and where we are procedurally, that this was an assault. No question. And so she points out she's in the midst of a surgery requiring focus and concentration. She could not abandon the patient. Her hands were occupied. She was in a small operating room with no ability to move or remove herself from the situation. To do so probably would have been malpractice because she's got a kid on the table. This is paragraph 8. Despite this, he repeatedly came in the operating room and displayed threatening behavior. She never experienced anything like it. She feared for her personal safety. She feared he would attack her based upon all of his words, actions, and threats. It made her feel vulnerable, helpless, and fearful. It was extreme, frightening, and outrageous. Another nurse in the operating room, not even the target of it, broke down as a result of it. And that's also in the complaint. I believe it's paragraph 189, if my memory is correct. She tried to get help. Joe D'Agostino, who we heard mentioned before, knew it was occurring while it was happening and did nothing. The operations supervisor on duty even went so far as to instruct other Northside staff to stay out of the situation. Do not help. She tried to get security involved. Security didn't help. And so that's only at that point did she call the police. Northside didn't like that at all. But I would submit, based upon the allegations in the complaint, which is all we're dealing with here at this point, not argument, that was her only option. And going back to these sort of, dispute resolution rules in the bylaws, I would submit to your honor, does not apply in a situation where you're fearful for your safety in an operating room with a kid on the table and someone's threatening you. And if that's not outrageous conduct, I don't know what is. And so a lot of the last hour was spent trying to blame her for the situation, calling her mad, frustrated, hot, self-serving, that kind of stuff. That's nowhere in the complaint. And certainly her saying, if you want to talk, let's talk about the scheduling shenanigans that you've been involved in. Doesn't say she was hot, didn't say she was aggressive. And it certainly doesn't excuse what happened after that. And so, again, under this standard of review that we have to apply here, we get to outrageousness. There's no question about it. And that's the version of the event that the court has to consider in this procedural posture. Look, if we get to trial in this case, Northside wants to argue differently, fine. But we're talking about a motion to dismiss at this point, or a motion to strike. In terms of the emotional distress itself, The only evidence before the court is what's in the verified complaint, what's in Dr. Harmon's affidavit, and is in Dr. Abrams' affidavit as well. Again, like my colleague for Northside, I'm not going to put that on the screen. It is in front of your court. It was submitted to your clerk as part of it. But as a result of this incident, Dr. Harmon was diagnosed with PTSD by a licensed clinical psychologist. She has seen this psychologist repeatedly since then. I don't know how many times, but it's more than 20, I think. I could look at the affidavit if I needed to do that. She'd never had any kind of mental health treatment in her life prior to this. And then this happened. Northside didn't like the way she handled it, which has been made abundantly clear. But she did everything she knew how to do in the situation where she was, feeling threatened. And the police did come, and they felt like it was serious enough without even talking to her. They talked to Northside staff first to arrest him, put him in jail. So if you take her version of the facts, which I presume the operating room staff similarly would support, you have what happened with the police who thought it was serious enough to haul him off. Again, that's set forth in paragraph 12 of her affidavit. She told the police that she did not want to press charges, but they took him away anyway. After that, we have the situation where, now again, to Northside's credit, they did remove him from the ORs on the days that she was operating. We could see that. That's good. But they started blaming the victim, and they started attacking her. The peer review referral is one part of that. And again, Your Honor has seen this, and I really, don't even want to kind of go there. But Northside's counsel revealed settlement communications in a way we think was improper. It's not to show bias of a party or a witness. And certainly, as they said before, they had 4,000 people looking at this, saying that proceeding with this case, given the facts that we think we have, could have a negative publicity component is just an observation of fact, not any indication that this is done for that purpose and that purpose alone. Be that as it may, having put that in the record, we have confirmation from Northside's counsel, which we heard again today, that the reason the peer review was instituted was because they thought she was taking an unreasonable position and wouldn't settle her claims. There's your malice. There's your retaliation. There's your improper activity that takes this outside the scope of any reasonable interpretation of the Anti-SLAPP Act. This is not free speech. It is a retaliatory referral that compounds the harm that has already been done. And so the only evidence before the court now regarding the severity of her emotional distress is what's in her affidavit, the diagnosis of PTSD, and the tying by Dr. Abrams to the assault event as the beginning triggering piece. It also says that the ongoing treatment has contributed. And so in terms of getting past on a 12-6 motion, on a motion to dismiss, Northside does not get to rely on argument. It does not get to rely on spin. It does not get to rely on characterizations that are not supported in the actual allegations, which is all they have done. And so, Your Honor, that's why I think we prevail anyway on the intentional infliction of emotional distress claim, with or without the peer review referral piece of it. And therefore, it is our contention that this motion should be denied. And frankly, I don't think it should be even a close call on this particular part.
Let me ask you that. Well, I tell you what, never mind, because that really goes more to it goes more to different aspects of the claim that are not the subject of this 9/11/11.1 claim. So I'm going
Right.
to try and mentally separate that out for a moment.
But unless your honor has other questions, I mean, that's really, I don't think I needed an hour to do that. So everything else is not really relevant, is kind of our point. And much of the presentation that was made by Northside really doesn't impact this very narrow specific issue that we're dealing with here.
Okay. Thank you, sir. Can you take down your screen share, Mr. Boyd?
Yes, sorry.
That's okay. So what I'd like to do is I'm going to take about a 5-minute break. And then I am going to come back, and I think what I'd like to do is hear from Ms. Flowers on the 12F motion, and then finish up the day hearing from, I guess, Ms. Lucas and Mr. Lazarus potentially on the 12B6 motions that are, of the larger complaint rather than the more isolated 9/11/11.1. It is 3:18, so let's say 3:25. We'll be back on, and I will be back with you then. Okay. Thank you
Your
all.
honor. Judge, a plaintiff is back whenever you're ready.
Thank you. Okay. Madam Court Reporter? Okay. So as I mentioned, we are going to move on to that motion to strike. Mr. Lazarus, can you tell me, is Dr. Weinstein a party to that motion, or is it just Northside's motion, or did you file your own same motion?
Your Honor, we filed a separate motion. I think it would make sense for Northside to make their argument, and then we have additional grounds for the motion as well.
Okay, thank you. I'm going to do that. Also want to, and as I said, what I'll do, Ms. Flowers and Mr. Lazarus, is I'll call on Ms. Flowers first, then Mr. Lazarus, and then I'll let Mr. Boyd respond. And then if either of you have a rebuttal, I encourage you to do so. I also want to say, just not significant of anything substantive, but I do appreciate Mr. Bauer, you're giving a young attorney the opportunity to make those arguments. There are courts that require it. But I think it's a great opportunity because young lawyers just don't get enough opportunities to make arguments in court. And so, metaphorically speaking, I'm glad that you're doing that. Ms. Flowers, I will tell you that I have read the motion. I have also read, or at least reviewed, some submissions that were made identifying the paragraphs, but suffice it to say that I understand your motion to be directed at striking some allegations that are directed specifically at Dr. Weinstein, that I think can fairly be characterized as not having anything to do with Dr. Harmon. And then I'm sure I'll hear from Mr. Boyd about why he thinks it's relevant to the issues raised by Dr. Harmon. But factually, I think we can all agree that those allegations were not relative to Dr. Harmon, other than that they are raised by her in her original complaint. And with that, I will hand it over to you, Ms. Flowers.
Thank you, and good afternoon, Your Honor. I do promise I will be brief, as I believe this motion is fairly straightforward. I would just like to highlight a few takeaways. So this motion turns on 3 points: that the allegations at issue were included for an improper purpose, they have no meaningful connection to the plaintiff's claims, and they impose immediate and significant prejudice. And that's the exact type of pleading abuse that OCGA 91112F is designed to address. So as you mentioned, Northside moves to strike specific paragraphs of the complaint that we have previously identified in Exhibit 1 of the motion. And these paragraphs consist of unverified secondhand accusations about alleged conduct years removed from the events at issue that plaintiff did not witness and that involved unidentified third parties. And these allegations do not advance any claim. They exist solely to inflame and stigmatize, and their presence on the public docket is itself prejudicial. So first, the improper purpose. The sequence of events makes the purpose clear, that the plaintiff's earlier draft complaint and mediation demand did not even include these allegations at all, nor did they offer any theory connecting them to plaintiff's claimed injuries. And only after mediation failed and after Northside declined to extend tolling did the plaintiffs threaten to publicize these accusations, and then, exactly as threatened, filed a complaint filled with them. And that timing shows that these allegations were not included to support a claim, but to pressure settlement and poison the jury pool. Second, there is really no meaningful nexus to the claims. Under Chappius, and that's Chappius versus Ortho, Sport and Spine Physicians, 305 Georgia 405, the court is empowered to strike scandalous allegations. And those are allegations which cast a derogatory light on a party, create a risk of prejudice, and create a risk of prejudice in a public pleading. And importantly, the court held in that case that when scandalous matter is at issue, the analysis extends beyond mere relevance and also must include prejudice. And the usual reluctance to strike is relaxed because such allegations can cause significant harm. And so here, plaintiffs misapply Chappius and repeatedly label that these allegations are relevant, believing that that is sufficient. But they never explain how unverified secondhand accusations involving unidentified third parties and not even witnessed or validated by Dr. Harmon could advance any element of their claims. Plaintiffs attempt to tie them to the negligent supervision and retention claim, but Georgia law requires a meaningful nexus. Even under cases like Newsom and Hardison that are relied on by the plaintiffs, prior acts, though not required to be identical, still have to bear a significant connection to put the employer on notice of the same type of harm at issue. And there's no such connection here. The plaintiffs offer no explanation or logical nexus showing how the improper allegations could have possibly put Northside on notice of any alleged propensity of Dr. Weinstein to engage in a heated verbal altercation with another physician over scheduling issues. The harm is just not the same. So the third and final kind of main point here is that there's immediate and substantial prejudice. Northside is a community hospital system, and allegations that it knowingly retained and a physician who engaged in serious misconduct directly erode patient trust, regulatory credibility, and institutional reputation. And because pleadings are public, that harm occurs the moment that the complaint is filed before any discovery, any evidence, and any adjudication can take place. And that is the precise concern that is addressed in Chapius, that allegations with only a tenuous connection to claims but a high risk of reputational harm are prime candidates for a strike. And separately, these allegations are pled simply on information and belief based on unnamed sources, effectively speculation layered on hearsay with no clear path to admissibility. And that just underscores that they are immaterial, impertinent, and improperly included in a public pleading. Finally, Northside is entitled to fees under 915.14 because these allegations reflect a litigation tactic, not a good faith effort to plead necessary facts. And Northside should not bear the cost of defending impertinent, immaterial, and scandalous claims that never belonged in the complaint to begin with. So that just brings me to the core point here, that these allegations do not advance the litigation. They do not clarify any of the claims. They only serve to inflame, distract, and prejudice. And that is why OCGA 91112F exists. And if these kind of inflammatory and unverified hearsay allegations that have nothing to do with the claims asserted are allowed to remain, plaintiffs will continue this kind of abusive litigation conduct. And for these reasons, Your Honor, Northside respectfully requests that the court strike the improper allegations and award the fees incurred in bringing this motion. Thank you.
Thank you, Ms. Flowers. Mr. Lazarus?
Thank you, Your Honor. Your Honor, we agree with everything that Ms. Flowers just said. Of course, the point I would emphasize, though, is as bad as this is for Northside Hospital, Dr. Weinstein, an experienced anesthesiologist, member of the community, these are scandalous allegations which do nothing to advance the complaint in this matter. For all of the reasons that were mentioned just now, we do believe that the Chapius case is directly on point. The prejudice here, even if there was some peripheral relevance, which we contend there is not, is so substantially outweighed that all of these allegations about this nebulous allegations of sexual misconduct, which have nothing to do with the allegations in this case, even construed most favorably to Dr. Harmon, should be stricken. In addition, Your Honor, to those provisions, Dr. Weinstein also believes, for the same reason, that these allegations about the TPO, which, as Mr. Bowers explained, was never pursued, which was dismissed ultimately by this court, should be stricken. In particular, I believe that is paragraphs 186 or 86 and 87.
186 and 187 or 86 and 87?
86 and 87.
Thank you, sir.
Thank you. That were stricken from that were ultimately about this after the fact conduct. The fact that a court entered an ex parte order certainly should not be a basis, where the fact that he was arrested would not be relevant if this ever came to court. As outlined in our brief, and as the court is well aware, the standard for a criminal conviction, not much less a criminal charge, is very, very intricate. There is no way that this would come in. This is a scandalous allegation. It is extremely prejudicial that he was arrested, again, after the fact. The pretextual arguments that have been offered to support not striking this, that it reflects on her mental state, again, is after the fact, doesn't go to support that. And certainly this should not come in because of the undue prejudice. This must have been extremely serious. He must be a bad person because he was arrested and there ended up being a TPO taken out against him. For those reasons, Your Honor, we agree wholeheartedly that these allegations, both the alleged sexual misconduct as well as the arrest and the TPO, should be stricken. And we would also ask for our attorney fees in the for the having to bring this motion to strike. Thank you, Your Honor.
Thank you, Mr. Lazarus. Mr. Boyd, your response, sir.
Yes, Your Honor. I start the same way as I did before, with the standard of review for a Rule 12F motion. Courts consider these, and the Court of Appeals has noted that these are often time wasters, and that's what this is here. The standard is that the allegations in the complaint that are challenged by the motion to strike have no possible bearing on the litigation. That is an even broader standard than a 12b6 standard. It is because courts do not typically want to strike potentially relevant allegations from the complaint on the front end before discovery. And that is why they are rarely granted. And again, the reason why I harp on standard of review is because we keep hearing from Northside that these are unverified or unidentified or unsubstantiated. It doesn't matter at this stage of the pleading. That's what discovery is for. And so these go, and again, Your Honor, if I can put the sort of aggregated allegations on the screen here.
I'd rather you didn't, because that's sort of what we're trying to engage in, is whether they should exist or not. And even if they should exist, I don't know that it makes sense to put them up on a YouTube.
Okay, that's fine. I certainly understand.
But suffice it to say, I have paid close attention to them. I have reviewed them. And I would say, other than the ones that were just added by Mr. Lazarus regarding the subsequent arrest of Dr. Weinstein, that my understanding of all of them is that they relate to alleged prior behavior by Dr. Weinstein that had nothing to do with his interaction with another surgeon, that didn't certainly have anything to do with his interaction with Dr. Harmon. I think I understand your argument about relevance for purposes of pleading is that the existence of those allegations put Northside Hospital on notice of Mr. Weinstein's, I think you characterized it as assaultive conduct or risk of assaultive conduct in your
propensities. Yes. Yeah, that's right, Your Honor. And so that plus a couple other things. First of all, we plead in paragraph 74, starting there, of the complaint. It goes on to about paragraph 79, I believe, that Dr. Harmon heard these things by staff members at Northside and reported what she had heard to Emily Mills. Including the potential that some of the patients that endured some of this conduct were elderly, which would create mandatory reporting responsibilities, just FYI. And so the allegation in paragraph 74 is that multiple members of Northside nursing and surgical staff described them to her. And these are assaults or batteries, actually, against patients. And 75 gives the specifics. She told Dr. Mills that the people who had informed her of these, if they're true, grotesque events, these batteries, were afraid to report directly to Northside out of fear, out of retaliation from Dr. Weinstein or the hospital. And that occurred no later than February 28th, 2024. about the same time, or during the same time, I should more precisely say, of the tinkering with the schedule. And only about, it's in the same year as the assault on December 20, 2024. She was told they would follow up. And that was it. But that goes to Dr. Weinstein's potential retaliatory motive against Dr. Harmon for reporting these things.
But I guess the point of the motion to strike, sir, is that, I mean, I understand the plaintiff is the master of their complaint, but like you could allege that by saying Dr. Harmon reported to someone at the hospital some behavior she thought was inappropriate by Dr. Weinstein, and she believes this is all retaliation. You don't have to spend 30 plus paragraphs talking about what those allegations are, which, as pointed out by Mr. Flowers, Ms. Flowers, and Mr. Lazarus, are hearsay built on rumor, built on whatever, right? And so I guess the where I'm trying to come down here is, as I understand 12F, right? The court steps outside of its purview, right? Its authorized discretion, and potentially abuses its discretion when it says, no, plaintiff, you can't allege that. But there's still a way to allege it in a way that is not, because all of this is subject to actual proof in the course of the litigation in a way that is not scandalous, right? That is not in violation of Rule 12F.
Yeah.
What are your thoughts on that, Mr. Boyd?
One, I don't think it is a violation of Rule 12F, because the courts make clear that just because there is an unpleasant allegation in the complaint does not mean that means it's subject to be stricken. We've cited those cases in our response to both Dr. Weinstein and Northside's 12F motion. If the allegations go to a claim, are relevant to a claim, then they stay in.
But that's my point. Why do the allegations of what was reported matter, right? Isn't the argument that Dr. Harmon thinks she was being retaliated against, right, by Dr. Weinstein because she reported him? It doesn't matter if she reported him for being late to surgery or reported him for any number of things that one might say, this guy's a problem. Why do you have to, how is it not gratuitous to throw this in there when it's unsubstantiated and not directly related to Dr. Harmon?
Sure. I mean, again, Your Honor, I would submit that the fact that it's unsubstantiated, we'll figure out whether it is or isn't during discovery. That's the point.
Sure. And that's actually part of my other issue is, if this were alleged in a manner that were not laid out the way it is in 30 plus paragraphs, right, then nothing's stopping Dr. Harmon from engaging in discovery to try and gather information about this that she believes would demonstrate that the allegations are true. And then we would argue about whether they were admissible and relevant to the issues in the case.
Yeah, precisely, Your Honor. Here's why. We've got a negligent retention and supervision claim. In the Northside's 12B6 motion to dismiss, they argue that the facts we've pled are not similar enough to what happened to Dr. Harmon to go forward. And so they argue it both ways. Your Honor, I mean, so long as we get to keep our negligent supervision and hiring claim, frankly, if we could do it generally like you just suggested, that's fine. We could do that. But what the follow down consequence of striking these allegations or not pleading them with specificity is that they're going to say, well, you don't have enough to succeed or get past 12B6 motion to dismiss on your negligent hiring and supervision claim, which requires the plaintiff to show that the employer here, Northside, and to be clear, he was a Northside employee. He was the director of the surgical center. He was in a very senior, not only anesthesiology position, but a management position, such that we contend that he was their agent as well. But you've got to show that there's enough facts to show that they were on notice of his propensity to engage in the type of behavior complained about. And so we have two separate things. We've got his battery of patients under anesthesia, and we have his battery of a coworker. And that's, again, I won't go through the details. That starts in paragraph 80. And so both of those things, and plus, again, we talk about in paragraphs 39 and 40 some anti-women statements that he has made. So when you have him denigrating female surgeons, you have him willing to engage in battery against a patient under anesthesia, and you have him willing to engage in battery towards a coworker. And again, whether it's the same enough to support a negligent supervision and retention claim, that's for the discovery process to sort out, and maybe a motion for summary judgment down the road if they think we don't have enough evidence at that point. But it's not the appropriate topic of a motion to strike or a motion to dismiss at this stage. And we do have to provide the detail. And they've argued we have to provide the detail in their 12B6 motion. So it's not, I would submit to Your Honor, it's not gratuitous at all. It's regretful that we have to do this. Not something I find pleasure in, or something like that. But it is relevant. And it certainly meets the standard of no possible bearing on the litigation.
About the Chappius case, Mr. Boyd, right? Because I heard from Ms. Flowers that you've sort of turned it on its head. Mr. Lazarus thinks that it's the end of the conversation and is dispositive of the outcome here. What do you think, sir?
No, I mean, that's the thing. I mean, it's still a disfavored motion. That's clear. And it certainly passes the relevance test, even if you use that language rather than no possible bearing, because of the negligent supervision and retention claim, which they've said the allegations are not enough, are not similar enough, which we again think is improper on a motion to dismiss. But we would be accused of not pleading enough if we didn't provide the detail. It was, like I said, I didn't want to do this when we put this complaint together. But
So, Mr. Boyd, I just going to tell you that I understand your factual and legal argument about why the prior stuff that Dr. Harmon is aware of about Dr. Weinstein might ultimately be relevant to your lawsuit. But I've mentioned several times that it was stated at length in about 30 paragraphs. That seems to me to be a little gratuitous. But my saying that doesn't negate the fact that the existence of that body of allegations, whether it's true or not, Dr. Harmon's awareness of it or not, the fact that it might have formed the basis of her making a report that she believes then resulted in some retaliation, those might all be relevant. It's the manner of the pleading that I have concerns with under the 12F standard.
Hey, Your Honor, it looked like I said, so long as it doesn't affect our ability to proceed with the negligent retention and supervision claim, we certainly would be amenable to stating those allegations more generally, so long as we are comfortable that we're not going to get hit with another 12B6 motion saying you haven't pled enough.
Well, given that Georgia law allows the wide latitude for amending pleadings without leave of court if it's against the same parties and that sort of thing, I feel like we can probably address that. But
okay, Your Honor, that's my concern. Is they don't have to be there so long as it is not going to negatively affect our ability to proceed with that. Really, the claims they bear on, which is both. Really kind of all of them with respect to the motivation of Dr. Weinstein, how it impacts that, particularly the report that Dr. Harmon made to Emily Mills, and the negligent supervision and retention claims. And so long as we don't get dinged on the back end on a 12B6 motion on that, we certainly would be willing to recast those allegations more generally.
okay, thank you, Mr. Boyd.
Sure.
Anything else, sir?
I need to address the fees part.
Okay.
Again, I don't think this is an appropriate situation for fees. And again, like I said, we were making sure that, that we could get past a 12B6 motion when we made these allegations. If the court agrees that a general allegation would be enough, then we're certainly happy to do that. We can take them out in an amended complaint with more generalized allegations.
Okay, thank you. Ms. Flowers, Mr. Lazarus, who would like to make any rebuttal?
I'm happy just to make two really quick points.
Sure.
My first point is that under Chappius and when scandalous allegations are at issue, that reluctance to strike allegations is relaxed because of the disproportionate prejudice that leaving those allegations can create. And the court in Chappius even says that the court in this situation cannot necessarily err on the side of leaving them in place, like in other types of motions to strike where it's just simply impertinent or whatnot. And then my second point would just be to push back a little bit on Mr. Boyd's contention that this type of harm is similar enough. In the cases that plaintiffs cited, the harm wasn't identical, but it was within the same kind of characteristic, whether it was sexual harassment that then led to further sexual harassment or sexual assault, whether it was a verbal and physical altercation with an employee that led to another physical and verbal altercation that involved different types of, I think one case was biting, but versus lunging previously. So that conduct was still of the same nature. And I just don't see a logical nexus between the alleged prior conduct here, and a verbal altercation with a completely different alleged victim. So that would just be my.
Thank you, Ms. Flowers. Mr. Lazarus, anything to add, sir?
No, Your Honor, thank you.
Okay. Well, I think probably my questions to Mr. Boyd made clear that I agree with you. I err on the side of not striking matters under 12F. I consider the plaintiff to be the master of their complaint, but it did feel a little bit gratuitous to me. And having said that, I would be inclined to strike the allegations that had been identified by the defendants. There's a table that was attached to one of them that lists the paragraphs. And these are as they relate to this alleged prior actions by Dr. Weinstein relative to other patients. Now, there's a lot of things that go with the next part of what I'm about to say. That's number one. I would be inclined to grant the motion to strike the allegations that are in, as I said, this is a table that was attached as an exhibit, paragraphs that are listed in that table. Now, as to Dr. Weinstein's argument about the subsequent TPO, I don't think that falls into the same category, right? Whether or not that occurred and what all it might mean or not mean, and whether it's relevant and admissible at any time in the conduct of this litigation is a matter for another day, not today. But I don't believe that it is subject to being stricken under Rule 12, under 911-12F. And so I'm not going to strike paragraphs 86 and 87. Now, having said that, it is fully my intention to allow Mr. Boyd to amend his complaint to make whatever allegations he believes he can make in a manner that I deem less objectionable, Mr. Boyd, right? Which is, I think it's fair if Mr. Boyd, on behalf of Dr. Harmon, believes that these allegations are in some way related, that Dr. Harmon's knowledge of the existence of the allegations, her alleged reporting of the existence of such allegations, her alleged retaliation by Dr. Weinstein against her for any or all of that, that's probably fair, but you don't need 30 paragraphs to say that. And those are all issues that we're going to get into the meat of them in terms of whether you can develop evidence that demonstrates that they put anybody on notice of anything relative to Dr. Weinstein. Certainly on notice of the behavior that Dr. Weinstein is accused of engaging in relative to Dr. Harmon. And so I am going to let you amend your complaint. I'm not going to talk specifically about the parameters of that because we've still got another motion to deal with. Last thing I will say is just because you win a motion doesn't mean you get attorney's fees. And so I don't think there's a basis here for awarding attorney's fees against Dr. Harmon on the 12F motion to strike. I think the remedy here is to get rid of the scandalous allegations, and that's what I've ordered to be done. And Mr. Boyd will be given an opportunity to file an amended pleading that does so. And so that's going to be my ruling on that. And then that sort of takes us directly into the 9, 11, 12B6 issue that we have not yet gotten to. Ms. Lucas.
Yes, Your Honor. Thank you. I also am going to be brief.
Okay.
I'm just going to focus on a few discrete legal issues. So I know you've read all the briefing and you've heard a lot of the facts today, and also several of the legal issues as well. So first, I just wanted to touch on plaintiff's claim for tortious interference, which
I'm glad you started. Forgive me for interrupting you. I'm glad you
Okay, no,
started
of
there because
course.
I want you to start with one question. One thing I don't understand. How is Penta, if in any way at all, connected to any of this? Because part of the argument here on the 12B6 is intra-corporate, et cetera. And so if you could address that for me as you're starting out on this one, that would be helpful to me.
Sure. I think Mr. Bauer touched on that earlier, but Northside has no relationship with Penta whatsoever. The only relationship that Northside has is that plaintiff has privileges at Northside, which means that she can use Northside's operating rooms pursuant to their policies and procedures. She's not an employee. And Penta is certainly not an employee, and there's just really no relationship there at all. But as far as the tortious interference claim goes, because of what I just explained, there's a threshold defect in this claim because Northside is not a stranger to these relationships. So with the privileges, when Dr. Harmon brings her patients to Northside, those surgeries are performed inside Northside's ASC using Northside's operating rooms, their staff, and their facilities. Those patients become Northside's patients, and they're paid for those patients. This means that Northside has a direct economic interest in those patients, and those relationships are interwoven. And so this is pretty much squarely what the stranger doctrine addresses. When a party with a direct economic interest in an interwoven set of relationships, they're just not a stranger as a matter of law.
Does that apply here though? Because I mean, I'm familiar generally with this idea that you have to be a stranger. And while both parties, Dr. Harmon and Northside, have an interest in the patient, they have an economic interest in the patient because they're all making money off the patient.
Sure.
Northside doesn't make money off the patient just because it's Dr. Harmon. I mean, if Northside said, we don't like Dr. Harmon, you shouldn't use her, use this other pediatric ENT doctor, that would potentially be an interference with Dr. Harmon's contractual and business relationships with her clients, even though you both have the same client or the same patient.
Sure, but they haven't said that. They haven't pled that.
I didn't mean to imply that they had said
Yeah.
the thing I was using as an example.
Right. No, but I mean, the complaint is based on that because the allegation that because Dr. Harmon felt that her OR time was being limited, that Northside was tortiously interfering with that, with her relationships with her patients. And that collapses for a couple of reasons. First, because Northside has the right to control its OR time, as Mr. Bauer got into in detail. But then what the law says is that because they have an economic relationship together with regard to these patients and this OR time, which is what she's, suing about, that she can't possibly, Northside can't possibly be a stranger because it has that direct economic interest in her using Northside's OR time.
I
So
guess where I'm struggling is I don't think anybody disputes that Dr. Harmon has a contractual relationship or some business relationship with her patients. And whether that is a relationship through Penta or
Mhm.
through Dr. Harmon directly. And I guess where I'm struggling is the fact that Northside also has a business relationship with that same patient doesn't make Northside a party to the relationship Dr. Harmon has with her own patient.
That's a fair point, but I think what the case law says is it does when you have a direct economic interest
Mhm.
in that relationship, right? So, like I said, when she brings her patients to the ASC, they become Northside's patients.
Mhm.
Northside is paid facility fees, its staff, certain of its staff gets paid for those procedures. And that's just a direct economic relationship between the two. And the only way to tortiously interfere is if you don't have that kind of relationship. And they do, so their claim can't really survive that.
Okay.
Unless Your Honor has another question about that, I was going to just touch on the vicarious liability claim.
Yes, thank you.
Sure, thank you, Your Honor. What plaintiffs are seeking here is to hold Northside vicariously liable for all of the alleged intentional torts committed by Dr. Weinstein. But first, I mean, Georgia law is clear that employers are not vicariously liable for intentional torts unless there's exceptional circumstances. And that's simply not the case here because plaintiffs themselves, if you can see from the face of the complaint, they plead that Dr. Weinstein acted out of personal reasons, personal animus, which they repeat in their response briefing. This is dispositive. Acting for personal reasons automatically is outside of the scope of someone's employment. For example, in the case of Piedmont Hospital versus Palladino, which is 276 Georgia 12, the Court of Appeals said, or the Supreme Court said, no, Piedmont can't be liable here. There was a alleged sexual assault of a patient, and they said there's no liability, vicarious liability here, because the second that this, even though it was a medical employee of Piedmont, the second that he started the sexual assault of the patient, that immediately moved outside of the scope of his employment. So that's just kind of the law there. It's just not reasonable to believe that assault, defamation, IIED, and the other intentional torts alleged could ever be in that scope of employment. Not to mention endorsed by Northside or done in furtherance of their business, as some of the other case law discusses.
Right, but on a 12B6, right, for the court to find that, the court would have to find that there is no body of facts, no universe of facts that the plaintiff could offer that could potentially support these causes of action. And that seems, given that you're talking about motives and we're talking about the circumstances. I mean, my recollection of those types of cases is that although they do tend to be adjudicated on motion, it's usually on a summary judgment motion,
No.
not at a motion to dismiss.
Sure, and I don't disagree with that. But I think what the key to focus on here is, again, the pleadings, which is all we can really focus on at this juncture. And the pleadings repeatedly allege that it was done for personal reasons. This was retaliation. This is personal. Dr. Weinstein is doing this personally. The response briefing says personal animus several times. It refers to the appendix in the complaint that discusses personal reasons. And so I think that is what is dispositive here, where I don't disagree with Your Honor that, typically these are summary judgment cases. I just think that it's so obvious from the face of the complaint that even Dr. Harmon and Penta believe that these were personally motivated, that's the standard. I mean, that just is not ever going to be within the scope of his employment.
Okay.
And so just to touch on ratification too, because they allege that as well.
Mhm.
And they're similar, but the law's a little bit different. What ratification requires is that Northside accept and retain the benefit of the torts. They don't make those allegations that Northside benefited from these torts, but I mean, how could they? What could possibly be the benefit of any of this to Northside? And then third, I'm just going to briefly address the remaining tort claims.
Mhm.
Because absent vicarious liability or ratification, those fail. But regardless, plaintiff's defamation claim. This fails because plaintiffs don't plead publication to a third party. And that's required by Georgia law. So internal communications within a hospital to medical staff, which is what happened here, are not publication under the intercorporate communication rule. And this is because, I mean, just from a practical matter, a hospital can't function if routine internal communications carry the threat of defamation liability. I mean, in an OR, or ER, it just gets very, it's life or death situations, like Mr. Bauer said. And so it's important that people be able to speak freely amongst, doctors, nurses, staff, and that's what happened here.
Are we talking about the peer review report, or are we talking about the statements allegedly made by Dr. Weinstein in the
Well,
room with Dr. Harmon?
I think that's a good question, Your Honor, because I'm not really sure. Well, first of all, the defamation claim itself, the count, is not pled against Northside.
Right.
But then, like you said earlier today, it's kind of, it seems that we need to address it because the vicarious liability could encompass all of those claims. So the claim for defamation is really against Dr. Weinstein, but to the extent there's any vicarious liability there, that's why I'm addressing it. But, even assuming there was publication, which we disagree with, but Northside wouldn't be liable anyway, because Georgia law bars corporate liability for slander unless the corporation expressly directed the employee to speak that way, which there's no allegation of that here. And I mean, how could there be? Northside didn't direct any defamatory statement, and plaintiff doesn't allege that they did. As for assault, again, I touched on this, I think, pretty in depth when I was talking about personal reasons,
Mhm.
but the complaint alleges personal reasons again and again. So that means necessarily that any alleged assault was outside of the scope of employment. It didn't further Northside's business. How could it? And so there's no liability for Northside for that assault. Plaintiffs attempt to recast it as work-related because it involved scheduling and took place in the ASC, but they can't say on one hand it was motivated by personal reasons and then simultaneously say it occurred in furtherance of Northside's business or with its approval. I mean, that's just not supported by the law. I think for the negligent supervision and retention claims, we covered that pretty well with the last motion. I will say that I don't disagree with plaintiff's counsel's musing that without the improper allegations that he can support those claims. I think that they base the negligent supervision and retention claims on a notice theory that was provided by all of those improper and scandalous allegations. And so without those, that claim fails. Regardless, the law requires foreseeability, and that conduct, like Ms. Flowers said, I think very, very well, just doesn't support that Northside would be on notice, or it would be foreseeable that he would then get in a verbal altercation with a co-surgeon. And I think we've already addressed the IAD claim in enough detail.
I think we've beaten that horse to death.
Yeah, I'll just make one brief point. I know your honors read the case law, and seeing to meet outrageousness, like it really does have to be some pretty crazy stuff, to use a technical legal term for the court. But even if even if this was a superheated argument, which is pled in the complaint, it just doesn't meet that really high outrageous standard. And finally, the punitives and attorney's fees claims. Those are totally derivative claims. So because there's no viable underlying claims, those claims necessarily fail. Your Honor, for all these reasons, we respectfully request that the complaint be dismissed against Northside, and thank you very much for your time today.
Thank you, Ms. Lucas. Mr. Lazarus?
Your Honor, I won't belabor too much. We've gone through a lot, but I do feel compelled to say that my client, Dr. Weinstein, he is an anesthesiologist. He's involved in a supervisory position at this surgical center, and he gets into what everyone's characterized as this altercation. What does not occur in this altercation is any type of physical touching, any type of gesture like pulling back a fist or an arm or anything along those lines, or any threat of physical violence. I know that plaintiff has taken the position that's saying, well, we're going to talk about this, or this, we'll handle this outside, or this is going to get handled, to construe that as an assault somehow or a threat of violence, but there was none of that. As Mr. Bauer explained, Dr. Weinstein had a reason to be there. He certainly had a reason to interact in managing this surgical practice, to interact. This, frankly, does not rise to the level of an assault. There's nothing there. There is an argument that occurs here, but this was not an assault under any stretch, regardless of how Dr. Harmon misperceived this situation from our perspective, or how she perceived it. It just simply doesn't rise to that level. And as was just explained, the court is very, very familiar, I'm sure, with the high standard for an intentional infliction of emotional distress claim. It's not just rude behavior, insulting behavior. As we all know from law school, it's that standard of outrageous. And I understand that this is in a surgical context. Dr. Weinstein certainly understands that. This surgery was completed. Of course, Dr. Weinstein successfully reversed the anesthesia, as was his responsibility. But regardless of if the parents had been there, as Mr. Boyd had talked about, if your child was on the table, that's not the situation here. This was a surgical procedure, an argument that occurred in connection with scheduling surgical procedure. It does not rise to the level of an intentional infliction of emotional distress. With regard to the defamation claim, certainly, as we've argued in our brief, and I won't belabor all of these other issues, there is the intercorporate relationship that was here. Who is this being communicated to? Other folks as part of the hospital system and the hospital network. And for that reason, Your Honor, those claims too must fail. Thank you.
Let me ask you a question, Mr. Lazarus, before I hand over Mr. Boyd to wrap it all up for us.
Sure.
In terms of his response. So what I'm cautious about for, let me back up and say this. So as to the assault claim and the IIED claim, right? So at common law and statutorily, right, all that's required for an assault is that someone be placed in fear of an imminent touching. And whether, in fact, that fear was objectively or subjectively reasonable is an issue of fact, I'm concerned. Similarly, while I might not find what's been described to me to be an event that would cause me great emotional harm, isn't that I'm concerned that the court is making a judgment call or an assessment that it should not engage in at the motion to dismiss standard, even if I, in full disclosure, think that, hey, based on what I'm seeing right now, I'm not sure it can survive summary judgment. What do you say to that, Mr. Lazarus?
Well, Your Honor, first of all, with regard to the assault claim, at some point, I think that everyone would agree, probably even I think that Mr. Boyd as well, that it just doesn't rise to the level. If someone had said that person gave me a dirty look, and I thought I was in imminent fear of an assault, there's got to be a limit, a threshold to rise to the level of an assault. And that has got to be some type of physical or words which are simply not here in this particular case, saying that this is going to get handled outside. Well, these are people who had business together. And I understand the court's concern, certainly, and I understand where we are in the litigation at the very beginning stages. But this does not, from our perspective, this does not rise even to the initial threshold. And with regard to the intentional infliction of emotional distress, we take the same position that this doesn't rise to the same threshold, particularly for the common discourtesies that one has to encounter in everyday life as a physician, as a lawyer. These types of things don't rise to that level, Your Honor. That would certainly be our position. There has got to be a minimum threshold to get even past this stage, and our position would be it does not rise to that level.
Understood. Thank you, Mr. Lazarus. Mr. Boyd, your response, sir. You're muted, Mr. Boyd.
Thank you. Sorry about that, Your Honor. Again, thank you for letting me respond. I'm sure Your Honor is aware, we have a very liberal notice pleading standard in Georgia. The standard is that the complaint must disclose with certainty that the claimant would not be entitled to relief under any provable state of facts. We cited all of the case law that says legal conclusions are appropriate in a complaint under Georgia state law. It'd be different if we were in federal court. And we don't even have to plead all the elements of a cause of action under some of the Court of Appeals case law. So we certainly tried to do that. Don't get me wrong, but the point of all of that is that the standard is a very, very liberal one in terms of what is required in the pleading. And again, I point Your Honor to the actual allegations in the complaint, not the constructions of them placed on the defendants. Again, they're doing their job, but I mean, I heard Mr. Lazarus again talk about this as an argument, saying that Dr. Harmon misperceived the level of threat, and that there's no allegation of a threat of physical violence. That's just not true. I'll point Your Honor to the allegations of the complaint where we specifically say that there is. So there's a lot of again, mischaracterization of what's actually in the complaint. We'll go to the allegations themselves. There's some ignoring of the allegations, and there's certainly an attempt to recast them in a way that we can't do on a 12b6 motion. So that's where I start. On the tortious interference claim, since that's the first claim that we talked about, Your Honor kind of put your finger on it immediately. These are different relationships. Northside might bill the client for the client being treated certain. That's their relationship with the client. But Dr. Harmon and Penta have their own relationships with those clients, which are entirely separate from Northside. And you asked the question about what's Penta's role here. Paragraph 17 of the complaint describes it. I mean, not to put too fine a point in it, Dr. Harmon is the sole shareholder of Penta. It's for medical practice. And so any surgical revenue that comes from her surgical services gets paid to Penta ultimately as a result of that.
But that was, thank you for clarifying that, because that was really the point of my question. Is I certainly understand, or at least I'm imagining that I understand, right? That Dr. Harmon is Dr. Harmon, and she operates as a medical practice, which is, I'm sure, some sort of corporate entity. My question though is, everything I've heard is that the privilege to practice and the block time for surgery that's granted is granted to Dr. Harmon personally, as a physician, and not to Penta, and that there's no actual relationship, implied or explicit contractually, between Penta and Northside, and certainly not Dr. Weinstein. And the reason for asking that is simply from a standing perspective. That's what I was trying to understand about, where does Penta fit in all this, except
Sure.
as the receiver of monies that would be paid perhaps to Dr. Harmon.
Yeah, and I think that is enough to give it standing. To go back though to something Mr. Bauer said at the very beginning of this, and I hope your honor will remember it, even though we've been here for a while at this point. But he said Northside has no privity with Penta. Again, I wrote it down because it was a very important admission by Northside's counsel on that. But now they want to say that there's some sort of intertwined economic relationship, and there's just not. Penta bills for its services, or Penta and Dr. Harmon bill for their services, and Northside bills for their services. And the allegation is in the complaint, and they're very detailed, that Dr. Weinstein, as an agent of Northside, this goes to both his individual liability and Northside's responsibility for him, acting in the course and scope of his employment, maliciously interfered with Dr. Harmon's patient relationships by improperly manipulating the schedule. Now, they try to argue that, well, Northside can do anything it wants, but that's not what's happening here. We have specifically alleged, and this is what gets us passed on a 12b6 motion, that the reasons for the manipulation of the schedule were malicious and improper. And so even if they had full flexibility, it doesn't matter because the reasons matter. For example, in Georgia and elsewhere, I know you have some background as an employment lawyer, you can terminate anybody you want to for any reason at will, unless it's for an illegal reason, because it's discriminatory, retaliatory, or because somebody's a whistleblower. So the mere fact that Northside has some discretion over the procedures that happen in its medical situation, it does not matter here. That's really a non sequitur or red herring, however you want to characterize it. And as Mr. Bauer said, there's no privity with Penta. So this kind of intertwined economic relationship argument really doesn't work here. And tortious interference claims, I think we cited them in our brief, have gone forward in this similar type of medical practice situations. So that piece of it. In terms of, so on the tortious interference claim, the stranger doctrine doesn't apply. We've got plenty of allegations of improper malicious conduct, which would meet that portion of the claim. And we're not required at this stage of the pleadings and litigation to prove those claims like we would before a jury. We just have to have the allegations in place, which we do. The other piece of it, going back to the stranger doctrine, I do want to raise is that the allegations are also sufficient to encompass patients who Dr. Harmon and Penta were not able to see because of the schedule manipulation. So those people never would have had a relationship with Northside, yet Northside interfered with Penta and Dr. Harmon's ability to treat those patients. And again, I don't want to belabor the point and get into the weeds too much, but we saw some of these the Wellstar privileges, the CHOA privileges, that sort of stuff. What is left unsaid there, suggesting that she has all these options, is geography. Will the patients go there? Can she go there? The nature of the type of services that are provided at those locations. Remember, this is a purely pediatric practice. You have to have people who know how to handle pediatrics pediatric anesthesiology, those types of things. And so that leaves this big gaping hole of, can she even do that? It also deals with whether she can get the schedule at the other places, what her block time is there, what the demand is. So none of that suggests that Northside has not interfered with her ability to do this. Like I said, we saw data from 2023 to 2025, I think. Certainly doesn't show what she was doing prior to that. And so, which we contend in the complaint was significantly more before Dr. Weinstein started doing what he did after she mentioned the fact that she's hearing these reports to Emily Mills at Northside, one of their senior managers.
Right, but that happened in February of 24, and then the altercation with Weinstein was in what, October, November? No, December.
December 24, yeah.
Right?
December
So,
2020.
okay.
Yeah.
Okay.
So they are strangers for this purpose. The economic relationships are not so intertwined that they can't be. We're at the basic pleading stage at this point on 12B6, and we certainly have patients that Northside never saw that would have been affected by this conduct as well. So there's no relationship there that Northside can rely on and say that they're somehow intertwined. We did plead specifically that this conduct affected plaintiff's contracts. That's in paragraph 157. State the obvious, physicians in there, you pointed it out, Your Honor, physicians in their medical practice have both contracts and business relationships with their patients. That should be obvious. We've pled that Dr. Weinstein interfered with that relationship. If you look at 160 to 161, we pled the harm. The Mulligan case was the one I was referring to before, Your Honor. I just couldn't bring it to mind when I was speaking about it before, where these cases have gone forward. It's on page 15 of our response brief. So we've pled all the elements, and certainly at a 12B6 stage, they should go forward. We should be able to conduct discovery on those. The other piece I would point Your Honor to, in terms of Northside's ability to be liable for Dr. Weinstein's actions and with respect to this claim, paragraph 18 and 19 says that he was an anesthesiologist and medical director at the surgery center. He was, again, a senior management employee in addition to being a doctor. Paragraph 19, we pled in the alternative that he acted within the course and scope of his employment or agency with Northside, was an agent of Northside, and or his actions were permitted and ratified by Northside. Again, under Georgia's liberal pleading standards, that is enough to at least create a question at this stage as to whether he was acting in the course and scope. We'll do discovery on that, and I'm sure we'll have arguments sometime down the road on that. But for now, that's right. So this idea that somehow because it's some sort of personal animus, that doesn't matter, because if he's doing it within the course and scope, even if it's motivated for some personal ill will, that doesn't take you out of the ability to have the employer be held liable in that situation. We cited a number of cases in our brief where even intentional torts, so long as they are sufficiently related to the job, can be the responsibility of the employer in that situation. We've also expressly pled in paragraphs 169 and 170 of the complaint, and I can show you those here, Your Honor.
I actually have it open on my other screen. So
okay, 169 and 70, that Northside was aware, did nothing to address it after complaint, condoned and ratified the conduct, and is therefore vicariously liable. And we also specifically pled that the people to whom these complaints were made are managers and agents of Northside. So again, I think this easily gets.
Well, hang on, just the paragraph you pointed me to, 2 points. One of the arguments that I've clearly heard from the defendants is one, that there isn't really a cause of action for what you're arguing about any gender animus toward Dr. Harmon, number one. And number two, how can you say that Northside is responsible for Dr. Weinstein's personal animus, right? Like, how are you saying I should thread that needle, sir?
Yeah, sure. So, like I said, there are plenty of cases in Georgia where even an intentional tort, is the responsibility of the employer if it's done in the course and scope of the person's employment. Any intentional tort has some sort of mens rea component. It's intentional. And so it's really a non-issue. It doesn't matter what the motivation is by Dr. Weinstein, whether it's personal, not personal, whatever. What we don't say in the complaint that is unrelated to the work. And so you have, if you're going to draw an inference in favor, inference somewhere, then that's the inference you should draw that it is. And that's what we've pled. And so, I think there's one mention in the entire complaint about personal animus. Mm-hmm. What doesn't matter for this purpose, that doesn't matter for this purpose, because what matters is the malicious conduct that he is engaged in as an agent of Northside, which is specifically pled in 169 and 70, and in addition to being ratified by them after it was called to their attention. So it doesn't actually involve just him. It involves Northside's management staff, which we plead are managers and agents in 170, who continued to allow this to happen. And to touch on the point of how does this benefit Northside? Well, I mean, if Northside thinks that Dr. Harmon is somehow shouldn't be there, they don't like her, there's plenty of reasons beyond the, economic interest in this that they could be using as to why they're doing this. And certainly the discovery process is appropriate to figure that out, particularly not just Dr. Weinstein, but everybody else involved in this and why they permitted it to happen. So from a pleading standpoint, like I said, I think we more than gotten there in terms of the allegations in the complaint with respect to the tortious interference claim.
Thank you.
I think next was defamation, I believe is the next in order. And so the primary argument, well, in the briefs, there are more than just this argument. So I'll kind of go through the briefs. First of all, we pled defamation per se. In paragraph 151, we list statements made by Dr. Weinstein that go directly to the business reputation of Dr. Harmon and Penta. Those include, she's a liar. She put her fingers in his face. She never sees patients post-op, suggesting she's not a good doctor or that she's a negligent doctor because she doesn't see her patients. She only sees Medicaid patients, meaning there's some sort of level of patient that she sees that is somehow not as good as everybody else. And that she doesn't see her patients. The allegation in 151 is she doesn't see her patients, only nurse practitioners do. And those are direct comments regarding her competence as a doctor. They go directly to her business and profession. And they also specifically mention her practice. Don't go to Pendle, you'll never see a doctor, you're only going to see a nurse practitioner. So those are clearly defamatory statements. They meet the standard of defamation per se. We pled that Dr. Harmon was damaged by those by those comments, sorry. And so that is all that is needed to state a claim at the 12B6 stage for defamation. Under the intercompany privilege arguments that are being made, what never is addressed that the intercompany privilege is limited. It only applies to people who need to have the information. A nurse, for example, does not need to know or be the recipient of the slanderous statements that Dr. Weinstein is making, and we can prove that at trial. The Scouten case from 2008, Georgia Court, I think it's Georgia Supreme Court case actually. This is a quote. It says, "Only those statements by one who, because of his duty or authority, has reason to receive the information, those are the only people covered by the intercompany privilege." And we can show that the recipients of these slanderous statements that we've identified don't fall within that umbrella. It certainly creates a fact question that can't be resolved at a motion to dismiss stage. Secondly, on that point, paragraph 85 states that the comments were made to medical staff at Northside. That can also include doctors like Dr. Harmon, who are not employees of Northside, but who are, there at the center, engaging in privileges. And so the intercompany privilege is not going to apply to those people at all. So again, at a 12B6 stage, this certainly gets past what is necessary to plead a viable defamation claim by slander, and specifically those made by Dr. Weinstein. So both in regard to the underlying claim itself and the vicarious liability claim, again, he's doing this in the course and scope of his employment. And those allegations are there as an agent of Northside, as one of its senior managers within the medical center, in addition to him being a doctor. All right. I think there's an argument in one of the briefs that there's no pleading of specific harm. I mean, with a negligence per se claim, harm's presumed, so we don't have to do that. And we wouldn't have to do it under a notice pleading standard anyway, even if we were just proceeding under a regular regular slander allegation. The harm, the complaint allegations for harm is pled is 152, 154. All right. I touched on the ratification. Again, Northside knew that Dr. Weinstein was making these statements. They did nothing. They continued. He was their surgical director in charge of the facility, and that's certainly enough to create a jury question on whether he was acting within the course and scope of his employment at the time he was making these statements. It was also about Dr. Harmon in her professional capacity as she was working there. So that is our response on the defamation claim. On the assault claim, I mean, again, we keep on hearing the recasting of the allegations. If you look at 176 to 184, this is a serious event. I know we're not supposed to be looking at Dr. Harmon's affidavit in this context, but that demonstrates what we could prove at trial. If you remember the standard of review that we're looking at here that I talked about at the very beginning, we certainly could prove the assault claims at trial. I think Your Honor pointed out, regardless of whether the perception was reasonable or not at the pleading stage, we have pled more than enough to show that Dr. Harmon was put in fear of her physical safety and in fear of an improper touching as a result of his behaviors. I'm going back to our appendix here to point to the complaint allegations. They start at paragraph 176. Dr. Weinstein said he was going to take her take her blank out. I'm sorry, Your Honor. Which again, I don't know how you construe that as anything but a threat of violence. This is not take it outside. It's I'm going to take her out. Paragraph 178, violently and aggressively jumped in her face while shouting threatening statements. 179, his statements and associated demeanor were overtly threatening. 180,
let me save you some trouble and some time. My only quibble with the assault claim is the extent to which it can be extended to Northside at this stage. Okay. As I said, you might not persuade a fact finder that it was reasonable for her to feel assaulted. But for pleading purposes, I think that you have sufficiently pleaded a claim for assault against Dr. Weinstein. The only issue I'm going to be looking at is the extent to which, if it is intentional, it can be laid at the feet of Northside. So
yes, okay, sounds good. If you'll indulge me, Honor, I can show you those complaint paragraphs here. This is from our appendix again. So paragraph 189, we specifically plead that management at Northside, people who are their agents, were aware of the assault at the time it was happening and did nothing. As you recall from Dr. Harmon's affidavit, again, we could prove this, and again, it's the standard of any provable state of facts, that I think it was Miss Downing, it was the surgical supervisor, actually told people, don't go in there. She asked that the circulating nurse contact security. That was ignored. She asked if the circulating nurse contact Jessica Downing, the director of nursing. That was ignored.
which might be poor behavior, but it's not an assault, right?
But it goes to the ratification by the employer allowing it to happen. This is all about ratification. This part of it. We've also got the other allegations in the earlier paragraphs of the complaints, 17, 18, 19, that all of this was done in the course and scope. So those are there as well. But you have Northside management watching this happening and doing absolutely nothing, which meets the definition, it frankly epitomizes the definition of ratifying the conduct. Paragraph 131 is when we refer to the complaint that she learned after it was happening that staff was informed to stay out of the situation despite them knowing what was going on. And so we plead ratification in 131 as well. Again, the other part of that is the context in which it happened. He is the ASC's medical director. He's not just the anesthesiologist. He is in a senior management position. We pled that. We pled he's their agent. The underlying dispute that ultimately precipitated and resulted in the assault was work-related. It was scheduling, again. We had pled, as Mr. Bauer had pointed out, that Dr. Harmon had been trying to work through this with Dr. Weinstein and Joe D'Agostino prior to this happening unsuccessfully. And then this happened with Dr. Weinstein. So again, there are enough facts pled there to show that he was acting in the course and scope of his responsibilities as the medical director, not an anesthesiologist, but as a supervisor at Northside, manager at Northside in this regard, at least for this, again, at least for 12B6 purposes. I would point more forcefully, I think, to to other Northside management allowing this to happen, knowing it was happening, watching it happening, and doing nothing. And so for purposes of ratification, that's our argument there. In terms of, well, again, on that point, I won't belabor it, but Mr. Lazarus said, again, confirmed for us here today that Dr. Weinstein was, in fact, in a supervisory position when all of this was happening. That was part of the argument that he made to the court just a few minutes ago. What does this leave? Perseverance, assault, defamation, the negligent retention and supervision we have talked about. Again, Your Honor, the portions that Your Honor would prefer not be in the complaint, in which you're going to grant the 12F motion on, that's the underlying allegations that should be sufficient. So again, we'll plead them more generally with less specifics, but on that point, we have pled that Dr. Weinstein has a record known to Northside of engaging in assaultive or battering behavior, both towards patients and coworkers. Under the Monroe case, which is kind of the leading case on negligent supervision, you just have to show that they had engaged in prior conduct that suggests a propensity that they would do it again. If anything, the batteries are worse than an assault where a battery didn't occur. Same thing with regard to the comments that he was making about female physicians in the workplace. It shows, again, that he had an improper motivation, and they knew about it. So that goes to those, in combination, goes to that claim as well. And I think, like you said, Your Honor, we have beat to death the intentional infliction claim. This is a unique situation. It's not like others because of the context where you've got a physician operating on a child when all this is occurring. That at the very least gets us past the outrageousness threshold. Again, calling this a disagreement downplays it. That's improper at this stage of the pleading. And so we think we have done more than enough to get past that threshold on the emotional distress claim. And because we believe that these claims will proceed, the punitive damage claims and the attorney's fees claims, those are not separate claims. The courts of appeals have said all you really need to do is plead, that you are seeking these remedies, because that's what they are. They are not an appropriate subject to a 12B6 motion to dismiss. And certainly because the underlying claims should go forward, the remedies we're seeking go with them as well. So that's the That's our point there.
Okay.
Unless your honor has questions, I can
Nope.
wrap that up.
Yes, sir. Anything else or fully wrapped up, Mr. Boyd?
Unless I've missed something, I think I've covered all the claims at this point. So I
Okay.
think we're good.
Okay. Ms. Lucas, Mr.
Yes.
Lazarus, I'm sorry.
Thank you, Your Honor.
Go ahead.
I
Go
just
ahead,
have it.
Ms.
I'll be
Lucas,
super
and then
brief.
Mr. Lazarus.
I
Okay.
promise. Just wanted to make a point as to tortious interference. Patients do have relationships with Dr. Harmon, but Dr. Harmon brings her patients to Northside for their surgeries, and then Northside makes money from those patient relationships. What the law says, for example, in Mabra versus SF Inc. 316 Georgia App 62, it says that if you have a direct economic interest in or would benefit from a relationship or contract with which you are alleged to have interfered, here this would be the relationship that Dr. Harmon has with her patients or Penta has with those patients, that you cannot, as a matter of law, be strangers to the contract and you can't have tortiously interfered. One other point is that you don't need privity to not be a stranger, and that's in the AMAC 2 LLC versus Web Limited case in 2023, which says that an interwoven dependency of relationships, even without privity, forecloses tortious interference. Second, while Mr. Boyd did cite some cases that said an intentional tort can be in the scope of employment, that doesn't apply here because the law is very clear that if acts are personally motivated, they're not in the scope of your employment, which is what plaintiffs say over and over again in the complaint. As to assault, hospitals, again, cannot be liable for tortious acts committed by employees outside the scope of employment. And Mr. Boyd spent some time on.
Hang on one second. Mr. Boyd,
Sure.
yeah, thank you.
noticed
Take
it.
down that screen share. Go ahead. Mr. Boyd.
Sorry. He spent some time trying to argue that Northside is liable somehow because they failed to intervene or didn't do anything, but that's not the standard for ratification. The standard is that for ratification to occur, Northside must have accepted and retained the benefits of the act. And plaintiffs don't plead that Northside retained or accepted any benefits of the alleged assault. I mean, how could they? Regardless, Northside has specific policies prohibiting assaultive behavior by medical staff and employees, and you can't ratify something that you categorically prohibit. Even if for defamation, the only way Northside's liable for those statements is if they authorized or directed them. Plaintiffs don't plead this either. And then one last point as to IIED. Georgia cases do hold that the court is allowed to decide the outrageousness, and therefore IIED at this stage of the litigation on a motion to dismiss. And I'll just give you a quick cite for that. That's Steffi v. Ameris Bank 366 Georgia App 699. And with that,
Sorry, can you give me that citation again?
of course, Steffi v. Ameris Bank 366 Georgia App 699. And with that, I thank the court again for your time.
Thank you. Mr. Lazarus.
Just one brief point, and I think the court alluded to it earlier, with regard to these allegations, and I'm not sure whether the plaintiffs intend that, but there are two plaintiffs, Dr. Harmon as well as Penta, and the way that the complaint seems to be drafted is that all of these allegations are certainly brought on behalf of both plaintiffs. Certainly Penta would not have a claim for the vast majority, if any of these claims, Your Honor.
Your Honor, I can clarify that. Certainly not the assault claim. Certainly not the intentional infliction claim. But with respect to the defamation and tortious interference claim and the remedy sought, Penta is asserting those claims.
Okay. So I think that's the end of all the argument. Please don't anybody say they have something else to add because this has been a long day. But let me say this. I don't think I have made any secret of sort of my general assessment of the case. I can tell you what my ruling is going to be on a number of things. I think there are a couple of issues on the 12B6 motion that I want to look at a little bit more. I've already ruled on the 9, 11, 12F motion. I've granted it. I would ask Ms. Flowers if you could provide me with a proposed order in Word format emailed to Mr. Freehoff so that I have something to edit. Because it's easier to do that than it is to create an order out of whole cloth. I would appreciate it.
Absolutely.
As to the 9, 11, 11.1, I don't think I made any secret of the fact that one, I wanted to confirm that we were talking about a fairly closed universe, which is now clearly on in the complaint, the claim against Northside Hospital associated with anything that is derived from the invocation of this peer review process. I think I've already said to Mr. Boyd and made pretty clear, I definitely think that under the strength of the Emory healthcare case that was recently handed down, and by extension, which is essentially the argument that Judge Watkins made in that case, that the initiation of that process, the filing of a claim, just as it would be if you were filing a claim against a lawyer, it definitely constitutes something that would potentially be protected action that's contemplated by the statute. And so then the next issue becomes whether or not, I think there is a little bit of uncertainty about the standard, because the case law, I think, is pretty clear that it's really a 9, 11, 12B6 standard, but because it's framed in a way that is there a reasonable likelihood of success on the merits, then it injects this issue of whether there's evidence. And so it gets a little muddy. But as I best understand it, I think the standard is is there a reasonable likelihood of success on the merits, i.e. accepting the allegations of the complaint, is there a cause of action there that could be proven? And I think the only thing that gets Dr. Harmon past that burden on that second step of the analysis is the fact that while filing such a claim or engaging in such a process is privileged and is immune, it's only immune if it's not motivated with malice, and that's the allegation that's been made here. And while, again, might not survive summary judgment, there is a universe of facts that Mr. Boyd can seek to identify and prove up that would attempt to argue or show that the referral to the peer review process was in fact motivated by malice and therefore outside the immunity protection that's guaranteed under Georgia law. Beyond that, that leaves me with the 12B6 motion. And since I've already said to Mr. Boyd that I'm going to have him amend the complaint to get rid of the scandalous matters relative to Dr. Weinstein, or get rid of is the wrong way to put it, to the extent that Mr. Boyd believes it's necessary to allege it in support of his causes of action, I believe that he can do it in a way that is less gratuitous and less scandalous. And the parties can develop that information to the extent that it is not to the extent that it is reasonably calculated to lead to the discovery of admissible evidence. In the course of discovery, the parties can engage in that. And if there's discovery issues, and of course, certainly once we get to the summary judgment phase, the court will deal with all those things when we get there. I think I've also made clear that it is a couple of things. Mr. Lazarus's last point about Penta, I think, is a valid one. And Mr. Boyd indicated that he'd be willing to amend his complaint to address that issue. And I will say, not for nothing, but the way the vicarious liability, the way count 3 is alleged, right? what it really intends to be is plaintiff believes Northside Hospital is liable for defamation because of Dr. Weinstein's alleged defamation. And that's not really what the complaint says. It's just sort of this catch-all circle in count 3. And so I think this entire complaint, as thorough as it is, which is why I think Mr. Boyd succeeds on many of his causes of action, ultimately, which is to demonstrate that that he has made allegations. There are pleadings in the complaint. So I say all that to say this. I fully expect that Mr. Boyd is going to amend his complaint because I've directed him to, at a minimum, about the allegations as to Dr. Weinstein. He's indicated he's willing to do so to clean up which plaintiff is making which allegation against which defendant. And because of that, what I'm actually going to do is I am going to spend some time with these causes of action on the 12B6 and provide the parties with an actual written order on which claims I think survive and which claims don't. If I think there are any that don't, relative to Northside, relative to Weinstein, although full disclosure, those are less likely, Mr. Lazarus. And then the reason I say that is once I give you that order, what I will do is include in that order a directive to Mr. Boyd to give him 15 or 20 days to amend his complaint, to, if possible, address those issues. And then if we need to go back through the round robin of a dismissal practice, we can do that. I'm hopeful that we can avoid it. But rather than Mr. Boyd filing an amended complaint that I'm just then going to say these things fail and he thinks he might be able to amend to fix it, I'd rather just do that once. And so my goal is to get you a ruling. I hate saying the end of May because that's a long way from now, and I get that. And I try really hard to rule when it's fresh in my head. But I think what would be helpful in this instance, if the parties don't mind, and if I'm not creating over much work, is for each of the parties to present me with a proposed order on the 9/11/12B6 motion. Mr. Boyd, if you can send me a proposed order on the 9/11/11.1 motion.
Will do, Your Honor.
The remaining emergency motions, except to the extent that the parties want me to seal something, which I'm willing to do, if the parties are in agreement, I think those motions are mooted. I would ask the parties to discuss and agree whether or not the affidavits that have been filed into the record should be the subject of an agreed protective order, which I'm happy to sign off on, and fully expected there would be one here.
Yes, Your Honor, we've actually presented that. We actually agreed on one and presented it to the court. So it's sitting.
Excellent.
On
it just hasn't gotten to me yet out of Mr. Freehoff's email. So thank you very much.
On that point, Your Honor, just real
Yes,
quick, the only thing that would potentially need to be sealed would be the psychologist affidavit in particular. If that is not going onto the public docket, which I don't know that it needs to be unless you need it for purposes of your order, then I don't think we need it sealed. We filed that thinking that it might be filed. And therefore, if we don't need to do that, then that's mooted as well.
Okay. Well, then here's what I think we're walking away from this now. And so today is the 7th. Is it realistic to ask you all to provide proposed orders as I've requested by the 15th of May, which is a week and a day from today?
That's fine with us, Your Honor.
Okay. And so to be clear, what I'm hoping for is a proposed order from the defendants on the 9/11/12F motion, a proposed order from Mr. Boyd on behalf of plaintiff on the 9/11/11.1 motion, and then proposed orders from both sides on the 9/11/12B6 motion. I say both sides. I guess I would also be looking for one for Mr. Lazarus, although if you guys can agree, that'd be helpful. But my goal will be to take those orders and spend a little bit of time like I said, I think my questions make it obvious which ones I'm going to be focused on and struggling with. But suffice it to say, just in the interest of candor to the parties, I suspect that the critical mass of this claim is going to succeed, is going to survive in some form beyond today, but perhaps be narrowed down in some way that I think more accurately reflects the nature of the dispute between the parties, subject to what's been pled. Anything else question-wise, concerns, issues for me to, oh, one more thing. Technically, is a motion to dismiss pending, so discovery is stayed. I expect that it would continue to be stayed until the court actually enters an order on that 12B6 motion, which is why I'm focused on trying to do so by the end of the month. What will happen is I will then send out, and you may get it before we open discovery. My general practice is to send you guys a notice of intent to issue court-ordered scheduling order. And it will have the most ridiculously short time schedules you've ever seen in your life. Because, you know, if I had my way, you get 1 month for discovery, which of course is ridiculous and not realistic. But that's done to remind the parties, hey, look, when you get this, sit down with each other, figure out what realistically is necessary to engage in discovery, and tell me what your dates are. And I'm happy if you tell me it's going to take 6 months, or if you tell me it's going to take a year to meaningfully to conduct discovery, I don't have a problem with that. Go for it. I'm happy to adopt your proposed deadlines. I just want to have y'all's meaningful input and hopeful agreement when you submit it to me as to what would be reasonable for that time frame. Okay?
Thank you, Your Honor. Thank you for
Okay.
all your time today. Appreciate it
No
very
problem.
much.
Any other questions? Mr. Bauer?
Yes, Judge Krause. So I understand you're denying the motion to strike under the
Yes.
anti-SLAPP statute. And it sounds like you've decided then that plaintiff has sufficiently pled a claim for emotional distress that she can proceed on. So I just want to make sure if we're drafting a 12B6 proposed order for you, we know what we need to draft. But if you're still looking at that claim more carefully, then I think we may have a little bit of inconsistency there, and I just want
Well,
to make sure.
Thank you for pointing that out. I will resolve that issue when I get to it and I'm actually drafting or editing the orders that I'm looking at. But the basis for the ruling on the 11.1 is, again, I believe it is something that is a matter of public comment, or whatever that phrasing is that I said much better about 5 minutes ago. But that beyond that, I think that plaintiff has satisfied its burden. And you're right, that may ultimately mean that I determine that the plaintiff has satisfied its burden for purposes of a 12B6 motion, but I'm not making that ruling today. And that's my error in being inexact, Mr. Bauer.
Okay.
I mean, I'm still asking Mr. Boyd for a motion saying that I'm not striking the pleading on that basis under 911 11.1. And I'll have to figure out how to say that. And when I rule, to make sure that all of my rulings are internally consistent.
Understood.
But thank you
You
for
won't,
pointing that out.
you won't be upset with us if we send you a proposed 12B6 order that dismisses the IIED claim against Northside.
No, I will not, because I told
Okay.
you to send me a proposed order
Okay.
that does that. But again, I want to make sure that my rulings are not internally inconsistent. And so I appreciate the point that you've made, sir.
And then my brain trust over here, about which I probably couldn't tie my shoes, has reminded me, do we need to discuss sealing the peer review information that has already been submitted to the court? We think
Well, that's why I asked about if the parties had engaged in a protective order. I'm happy to clean up the pleadings in any way that's necessary, that will retroactively exclude those matters and have them be sealed in a way that everybody is sure that those matters are subject to seal, and that they ought best be kept out of the public pleading docket. But if there's no dispute, then absolutely send me such a ruling. Let me look at the proposed order, and I'll take whatever action we deem necessary to do that.
Okay,
Yeah.
I'll reach
We don't
out to
have
Mr. Boyd and we'll coordinate on that.
We won't have any objection to sealing that stuff, given your Honor's ruling on those issues. So,
Okay. Anything else from anybody else?